If you are a participant, please press pound to continue.
Okay, folks, sorry for the technical delay and the technical difficulty I'm having with my laptop. Bring this meeting of Amador County Board of Supervisors to order. Supervisors came out of closed session. 1A, direction given to staff. 1B, direction given to staff. 2A, update given. 3A, confidential minutes were approved. We're on to the regular session now. If you wouldn't mind standing for the Pledge of Allegiance. Pledge of allegiance to the flag. Liberty and justice for all. I am not seeing one of the members for the 4A on the regular agenda. Oh, excuse me, I'm passing away. Let's back this truck up here. Got frazzled with computers, so here we go. Public matters not on the agenda, discussion items only, no action to be taken. Any person may address the board at this time upon any subject within the jurisdiction of Amador County Board of Supervisors. However, any matter that requires action may refer to staff and or committee for report, recommendation for possible action at a subsequent board meeting. There's a 3-minute time limit. Anybody like to come forward?
Lois McDonald in Jackson. Glad to see you again today.
Morning.
New California State, we have our 10th constitutional default. This will be our last one. And so we're going to be scanning through this and leaving you copies of it, okay? And so I thought that we, the people of the state of California, notice to all Californians a declaration of the 10th constitutional default. The citizens of New California have decided to remedy the abuse of power by the government of California by exercising their right to form a new state, provided in the United States Constitution, Article 4, Sections 3 and 4. We are determined to live under a state government in the United States of America and under the Constitution of the United States. There's been a lot of claim that we are trying to secede from the Union. This is not true. We want to be part of the Union, the 51st state. But the people of California are suffering from a tyrannical state government, which fails to provide a Republican form of governance, enables and supports across its southern border the invasion of the United States of America by illegal foreign nationals, and protects vicious criminals who commit outrageous acts of violence upon the citizens of America, all caused by a government of and for a monoparty system led by a tyrannical, pusillanimous dictator who openly defies federal laws. California state violates the United States Constitution, Article 4, Section 4, which would guarantee to every state a Republican form of government. And the United States Constitutional Article 6 and the United States Constitution First Amendment. Also, the United States Constitutional 14th Amendment. So now we'll have Chris Street continue reading. Thank you. And I have the copies of these for each of you.
Good evening. Good morning, Board. Chris Strong, not Chris Street.
Good morning.
Write my name on here. Okay, yes, we're continuing on with our declaration of default regarding California's standing. Thank you. And this would be count 6 of the Newsom indictments of treason. There's a serious problem going on in our country with our governors, and as some of you may or may not know, under the U.S. Code, Section 2381 of Title 18, treason says, whoever owing allegiance to the United States levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason, and shall suffer death or shall be imprisoned not less than 5 years, and fined under this title, but not less than $10,000, and shall be incapable of holding any office under the United States. And the United States Supreme Court ruled that one need not pick up arms in order to levy war in U.S. v. Boer, 1807, Title 8, 469, Section 684. Treason, it says, is attacking or betraying a government authority to which one owes allegiance. And then California Penal Code, Section 37, defines treason as warring against the state or adhering to its enemies. As a felony, treason carries the death penalty or life in prison without the possibility of parole. And we have at the current situation a crisis, a very serious lack of defense of our borders, and it's simply not tolerated, and we're not going to tolerate it, and it needs to be accounted for. And this count 6, this indictment, is not limited, includes, but is not limited to the 2020 pandemic treason with fraudulent mandates under the auspices of a foreign government, United Nations, and the World Health Organization that destroyed businesses, commerce, education, civil liberties, and the deaths of millions of California citizens, as you're probably aware. Also, the Employment Development Department has fraudulently given aid and comfort to an enemy or enemies of the United States with the funds of the people of California. And the election, there's fraudulent counting of the ballots from California's 58 counties by the use of electronic machines. And New California has data to support all this, and we're in the process of providing this throughout the state.
Let's go ahead and wrap this up, if you don't mind.
And the 2020 Electoral College treason, it signed the fraudulent certification of the 55 Electoral College votes of the state of California, and state budget financial treason. They knowingly making fraudulent state budgets with the knowledge of the government of California would be economically destroyed. So we're doing all we can to keep this state, to find a solution for this state. New California has a financial plan to come out of all of the basically the economic default that we're in the process of. And as you're probably aware, that California is losing billions and billions of dollars compared to the previous year based on all of the companies that have left the state and the people that have left the state. So we're just notifying you and asking for your support to follow up and understand what this statehood process is, and we'd love to support you however we can.
Thank you.
Thank you.
Okay, anybody else from the public? Anybody on Zoom?
Not at this time.
Okay. We will go on to the approval of the agenda. I'll move.
Second.
There was an email talking about Kirkwood. As far as, did that get pushed to? Well, we'll talk about it at that time. So, Supervisor Forster made a motion. What is our second?
Mr. Chairman, item 4A, I think we're gonna have to push to the 27th, so we can take that one off the agenda.
Okay. 4A push to the 27th of June.
Second.
Okay, Supervisor Crew is a second. All in favor?
Aye.
Aye. Any opposed? Okay, it'd be 5-0. Approval of the items on the consent agenda.
So moved.
Second.
Supervisor Neto, Supervisor Axe. Call for the vote. All in favor? Aye.
Aye.
Opposed? Okay, again, 5-0. We will, 4A has been pushed to the 27th of June, so we're on to 4B, discussion of possible action relative to the responsibilities of the sheriff coroner upon a person's death.
Morning, Mr. Chairman. Good morning, gentlemen.
Morning.
So I was invited here by Supervisor Forrester. There seems to be some misinformation, whether it's intentional or not, on our policy and where we stand with our coroner's duties, specifically in the safeguarding of property. And I brought Under Sheriff Middleton with me. Under Sheriff Middleton and I both served as the operations captain, which oversees our coroner's bureau. And he specifically was a lieutenant who oversaw the coroner, the chief deputy coroner. So he's got intimate knowledge in how our policies, how the law works, including myself. The government code is fairly specific on how it governs coroner's duties, along with the penal code, probate, et cetera. And I want to explain that when Supervisor Forrester got a hold of me, our policy hasn't changed in the time that I've been here, which is over 25 years. So under Sheriff Prismich, under Sheriff Martin Ryan, including myself, our duty is to safeguard property and make sure that property goes back to the correct people and is also not stolen. We've had a lot of incidents where during a death, people come out of the woodwork, whether it's family members, whether it's people, unscrupulous individuals in the county who look for an opportunity to steal property. We've had entire safes removed from residents that we put a coroner seal on, that they knew that it was vacant and nobody lived there. So that responsibility lies on us to make sure that we do safeguard that property, and that property is always valuables. That's cash, jewelry, and firearms. And I think where the issue comes in is the fact that people are trying to spread that misinformation that we are somehow anti-Second Amendment, that we want to take people's firearms. In reality, that is not a process that we take lightly. It's a lot of work for the staff. It's a lot of work for my evidence technicians to make sure they categorize, log, and get that property back to the people. And that's exactly what it is. It's safekeeping. We don't seize the firearms during coroner's investigations. We safeguard it so it does go to the proper people. And unfortunately, we've had some very contentious coroner's cases where family members go against other family members in a time of mourning. It gets extremely nasty. And our job is to make sure that the property, once released, goes back to the proper people who are entitled to that property. One of the codes that the undersheriff is going to talk about is the penal code, that people are attempting to paint my office as this is our policy, when in fact it is a penal code that says you shall, as a law enforcement agency, do this. It's not if we want to, it's not if I agree with it, it's you shall. And I can tell you every sheriff's office is following this law. Every sheriff's office from Shasta County all the way down to Mariposa, El Dorado, Placer, do exactly what we are doing.
How long has this law been in place, or this penal code?
The penal code changed from the best of my recollection, Supervisor Oneto, it's been over about a decade or more is when the penal code changed. We safeguarded the property, but then we were able to make that determination when it specifically came to firearms and ammunition on how that was going to be released. And I think every sheriff's office maybe did it a little bit differently, but we released that property once we were able to determine this person is not precluded, the guns weren't stolen, then the property went back. The law changed. There's a penal code that governs, you have to go through DOJ, and DOJ now gives us a letter saying, this person is eligible to have these firearms. Once again, it is a shall law, not a if we want to choose to follow this law. So with that brief introduction.
Can you cite that code?
The undersheriff will get into that, Supervisor.
Okay.
Good morning, Undersheriff Brian Middleton. The sheriff took my first 2 pages of notes here, so I'll try to catch up. But just a little bit of a lesson here. 48 of the 58 counties in the state of California, the sheriff's office is the sheriff coroner, Amador County included. Average last 3 years, 200 deaths annually are reported to the sheriff's office. Of those deaths, approximately 170 of those deaths are coroner's cases. For purpose of simplification, non-reportable deaths to the sheriff's office would be an attended death, like hospice, somebody who was on hospice. California 27491.3.
What's that number again?
27491.3, and that's California Government Code. And that's basically the government code that directs the coroner during a reportable death to take custody of personal effects, valuables, and property of the deceased. I'm going to say valuables because that's really the whole thing. I know we're here to talk about firearms, but it's all valuables or all items of value.
So that's 27491.3?
27491.3. That basically directs the coroner to take those valuables until a disposition of the rightful, lawful owner can be made. There are many times when the coroner is on the scene of a reportable death that the next of kin, who would be the rightful owner, sands a will of that property. And that next of kin is not on scene. It might be a boyfriend, it might be a relative that's not the next of kin. Hence the purpose of us taking that property to make a lawful determination of the rightful owner.
Do me a favor and read what verbatim from it, or it gives you that, Roy, you have to.
Sure, I have most of it notes in my, you can read the entire code. It's on fine law, and actually.
You want me to read it for you? I wouldn't.
So I can tell you right now, Supervisor.
It says
any death. Supervisor Onetto?
Yes.
The law is not a shall law. It says the coroner has the ability to safeguard this.
May. That's correct.
Yes, correct. And in the interest of providing a service to the public and safeguarding property, we err on the side of caution because we have dealt with numerous cases where it has absolutely gone sideways. And when we haven't safeguarded the property, then now we're opening the county and my office to open up to liability of not doing our jobs. I know exactly where you're trying to go with this, sir. You're trying to paint us that we are out of line, that we are going above and beyond what the law should do or should say, and that is not the case.
No, Mr. Sheriff Redmond, I happened to talk to Sheriff DeAugustini just the other day. It's over at a grand opening for DeAugustini Winery. He's like, we don't do that in El Dorado County, or he didn't. I was like, really?
That's not factually correct, because I just talked to Sheriff
very
Lykoff.
rarely.
I just talked to Sheriff Lykoff, who's the current sheriff of El Dorado County, and he said absolutely they do exactly what we're doing.
That is not what Sheriff DeAugustini told me. Not saying they never do it. He says generally they don't.
They actually have the same policy, almost word for word, than us. And
Not what he told me.
We spoke to, well, we can sit up here and tell stories all day long, sir. All I can tell you is that we checked with the surrounding counties, and they are in agreement with us, including El Dorado County, who the current sheriff is Jeff Lykoff. Do we have further questions on 493 or 491.3, sir?
No.
Okay.
Not at this time.
Occasionally at the scene of deaths, there are firearms. The deputies will take firearms for the purpose of safekeeping. Once we take firearms, there are several laws in place that dictate what we do with those firearms. Penal Code Section 33-855 requires any agency or court that has taken custody of a firearm or ammunition shall not return the firearm or ammunition unless the following requirements are met. The individual presents notification per California Penal Code Section 33-865 that they are eligible to possess the firearm or ammunition. The agency safekeeping the gun has access to the automated firearms system, and that the firearm is not listed as stolen. The firearm has not been listed as lost. Penal Code Section 33-850 requires the person who claims to have title to a firearm shall make an application to the California Department of Justice to determine if they are eligible to possess a firearm. The California Department of Justice makes the determination of eligibility, not the Amador County Sheriff's Office. The firearm is not sent to the Department of Justice. The firearm is kept at the Amador County Sheriff's Office until we're notified that the person attempting to obtain the firearm is eligible to possess the firearm. Although the ability to own and possess firearms is certainly a political hot topic in the state of California and in the United States, the California laws that are in place, the Sheriff's Office has sworn to follow. The laws have been set in place to ensure that the rightful owner receives the property of the decedent, and that the property, if the property is a firearm, the rightful property owner is able to possess that firearm. Any other further questions?
I have one there. And it's firearms and other valuables, which could be in a lock safe or any place else. But when you secure the house, is there a notice put on the house? And is it, people have still tried to get in the houses even with that notice, from what I understand?
I didn't cover that point because the sheriff sort of touched on that topic, and I actually don't like to say it publicly. When the coroner does a coroner's investigation and he's at that resident, when he's done with his investigation, he seals that residence. That is a seal, that's a sticker that goes across the door that's a misdemeanor to break if you enter that residence. It's not much of a deterrent for you to break a sticker and expose yourself to a misdemeanor when your intent is there to commit a theft or a felony. We have had coroner's cases in the recent past where there was no next of kin and that house stayed vacant, and we had chased that property as far as Nevada City. There's people as far away from Nevada City coming to this. I don't know how the criminal internet works, but if you leave something unattended, there's going to be people from all over the state coming to look at it or take it. Supervisor Oneto should know that. That's a very similar situation happened out at the cogen plant years ago. We arrested people from Visalia at the cogen plant.
One more question. I've seen two different cases, and explain to me the difference. One case, the next of kin were present and opened the safe willingly, and the firearms were confiscated. In another case, the next of kin said they did not have access to the combination to open the safe, and the safe remained in place. What's the difference there? If it's a locked safe, why not just leave the firearms in the locked safe?
People will steal the safe. The entire safe will get stolen.
But in the other case, the second one I cited, the safe, as I gather, was left in place.
If we don't know what's in the safe, if the safe's not open and we don't know there, that's a Schrodinger's cat situation.
We attempt to do our due diligence, and the difference in when you talk about next of kin is there are family members such as children that are legal next of kin. And typically what we're dealing with is where, say you die, Richard, of a heart attack. We go to your house, we conduct our coroner's investigation. It's apparent there's no nefarious activity. We're not going to take any valuables because your wife is the spouse and the next of kin. We're not going to take cash, jewelry, guns, anything along those lines. However, if you're divorced, your children are the next of kin. Your wife is no longer your actual legal next of kin. And if you die and you're alone in that house, we are going to safeguard that property. So your children or whoever you have determined, sometimes that takes days. And like I said, it's gotten very contentious between family members of who the rightful heirs are. And that is not something we do at scene. We, one, have to investigate the death to make sure there's nothing that is illegal. It's not a homicide, because we look at every death potentially as a homicide in Amador County. That's how we approach our coroner's investigations. So that's the difference. I've heard a lot of talk lately about, well, if I die, are they going to come in and take all my firearms with my wife here? The answer is no. It's when it's a vacant residence. As the undersheriff indicated, a coroner seal is not much of a deterrent, and we've had entire safes removed from that residence. If we get somebody that is willing to open that safe and they are not the spouse, we are probably going to safeguard those firearms until we can determine who the actual heir is.
Generally, people are happy for us to secure the property until a determination is made. That opinion might change after they get to the GOJ rules of returning those firearms. That's out of the sheriff's office control. We don't make that determination anymore.
So when the spouse is still in the home, normally you would not take the weapons.
We typically will not take anything, whether it's
Okay.
cash, valuables, jewelry, firearms.
I know when my first wife passed away, the sheriff deputy came by, and because she was very sick, she had lots of medication, and he confiscated all the medication in her name. So I know that, type of situation happens.
So medication is different. That's typically it's not a valuable, but it's part of our investigation.
Right.
Because until we can run toxicology and do what we have to do as coroners, like
I was perfectly happy
Yeah.
to get rid of it.
and most people are, because they do have a narcotic that isn't prescribed to them, so they could no longer actually legally possess that. So our deputies will take all of that, and that's part of our coroner's investigation.
Right.
The one thing that we will take is a driver's license, California driver's license that belongs to the state of California. We will take a California driver's license. The narcotics will count to see if they're taking them as prescribed, and run a toxicology, and then those are destroyed.
Right. Supervisors, any other questions?
Yeah, I have one. Do you give receipts for guns when they're taken at the scene?
Yes.
Yes and no. So when we have 40-plus firearms, we will take those, we photograph them, and we categorize them, and typically we will do that at the office.
And then they'll get a receipt.
And then they will get a receipt for all of those firearms.
So you're saying you might take up to 40 firearms with no receipt, and I like guns, and guns run, average decent gun runs $500 to $1,000 bucks. Some may be 10,000, some may be 100,000. If you get like a Walker Colt, you might be talking $500,000, and there's no receipt.
Oh, a receipt will be provided. There's also photographs.
Yeah, but once you get to office, so what's to say that person doesn't stop alongside a road, throw a gun up, or a couple guns up behind an oak tree and drive on the office?
So now you're accusing my deputies of theft.
No, I'm just saying.
No, that's exactly what you're doing, Supervisor.
I'm saying reality is this: it happens. It happens. We're human.
Let's not
That's why.
the audience,
Hold on,
please.
Mr. Chairman. That's why there's safeguards in place, whether it's a board of supervisors, whether it's county employee of any sorts. It's like that's why we have records.
Yeah.
So it's to keep people from being put in a position they should not be put in.
We have body cameras, which capture all of it. We have photographs that we photograph all of the guns as they sit in place before we remove them, or in the locations that we do find them. So those are categorized.
So at the scene, they're all photographed?
Yes. And
Okay.
I have yet to have a complaint that we have somehow lost or stolen somebody's firearm on a coroner's case.
I just had people tell me that they were given no receipt and they were not happy about it. And I thought if you're doing photos of them.
Typically, we try to do everything we can to make sure that we do get them a receipt before we leave. But when you have 40 plus, and we've taken up to sometimes 80 firearms at a location.
So you're saying it's your policy that there will be a photograph taken of that gun before it leaves that premise,
Yes.
the home?
Yeah, overall photographs, yes.
Overall,
If we have a gun safe and we open it up and there's 80 firearms in there, yes, we're gonna be taking photographs. If you're asking if we take a photograph of every single firearm, that typically is not done until we get back to the office
okay, that'd be my question.
while they're entered into our system.
Thank you.
Any more questions from the supervisors? Okay, let's open this up to the public. Please.
So, my name is Gina Martin, my brother, Mark Dufresne.
Morning.
Morning.
Our mother passed away June 3rd. She passed away at her friend's house, Charles Huffman, in Jackson. Mark and I went to the house while our mom was still there. Deputy Brandon Dossier was there. He took a statement from Mark. He told us that our mom had 2 addresses and that he needed to seal both of them until the sheriff's investigation was completed. He said he had to take all valuables, including guns, jewelry, et cetera, for safekeeping. I told him we had a trust, and I was the trustee. He said he still needed to proceed and told us to meet him at my mom's house in Ione, not the scene of the death.
Well, that's when you went and sealed the Oak Manor room.
And so he went to Oak Manor, and he told us to meet us in Ione. She had lived in Ione for 6.5 months. I also have durable power of attorney. So at the time of her death, everything passed into the trust with a pour-over will. It wasn't hers anymore. It was our property. I tried to contact our trust attorney. It was Saturday. She didn't have her phone. She was working cows. We met with Deputy Dossier at my mom's house in Ione, continued to protest about taking the guns. They were in a very, very nice safe. It would take a forklift to get it out of her house. And at that time, the guns were very secure. There was no problem, and the property of the trust. Deputy said, it's the county's policy to take all the guns. I asked if it's policy or law. He said policy. I said, I don't like your policy. I protest. I don't think you should take them. My brother said the same thing. Showed him a digital copy of the trust. He looked at it. He said he had called his superior before he left Jackson, told him about the trust. They said, take the guns anyway. He called twice from my mom's house, or our house. It wasn't hers at that time because of the trust. He called twice. They said, take them. I don't know who his superior was. We kind of think we might know the name, but I don't have for sure. The sergeant that was telling him to take them. And at that point, I wanted proof of what he was taking. There was 14 guns in the safe. And he said he'd give us the receipt when he put them in the evidence. I said, I need a receipt now so we know what you're taking. It was 1 deputy, 1 car. He was going to drive from Ione to Jackson.
Did he take pictures, do you know?
Not with a camera.
No.
I wrote out a receipt.
Well, with a cell phone, maybe?
This is our receipt. I wrote it out.
So, yeah, we had a receipt to where.
And we kept
We all three
protesting. We
signed.
kept telling him it was wrong. Our mom just died.
Gina, did he take a picture of the cell phone, do you know?
Not that I'm aware of. I didn't see him do that. This is a hard time.
I know, I'm sorry.
Within about 2 hours of my mom's death.
She just died, and he's telling us we have to do this. And so I wrote out the detailed receipt. We signed it. He said he signed it. He said he didn't need to because he was going to make one out when he got to Jackson.
We offered him a copy. He
And-
declined it.
And
Did he do that at that time? Did you now have a receipt that they,
that I made.
not above what the deputy made?
We went
No,
out one on Monday.
no, we had to get it on Monday. This was Saturday.
I understand, but you eventually got a receipt,
Yeah, yeah.
and it matches your receipt.
Yes, it does.
Yes.
Okay.
We're taught, our mom and dad taught us, law officer, peace officer, you do what you're told. And so we did what we were told. Maybe we shouldn't have opened the safe, I don't know. I think this was an illegal search and seizure. I think it violated our Fourth Amendment rights. And so on Sunday morning, we went to the sheriff's department and talked to a deputy, and he said the same thing, it's policy. This is what we do. I gave him a hard copy of the durable power of attorney and the trust at that time, but he said there was nothing we could do. We would have to go through all the paperwork to get him back. Monday, we returned and spoke with the evidence technician. We were advised of the process. We're gonna have to pay, it's gonna cost us money, it's cost us a lot of time, it's cost us a lot of heartache. I think this is the most incompassionate thing anyone could do to a family at this time. And I think there was poor training for the deputy. I don't think he wanted to do this. I think he knew it was wrong. And so I think policy needs to change. We've talked to a lot of people. This is a big safe.
It's this big, that tall. I mean, the house is an old barn, and it actually had to go through a stall door. It won't fit through most doors, so, which would be very hard to them. So it was very secure where everything was already at.
And it wasn't the scene of the death.
And nothing was laying around. It was not the scene of the death. And we just kept telling it was his policy, and
Your question on that, didn't you ask about where the policy was and they told you it's on the website? Or
Yeah.
You said you searched for hours and couldn't find it, I thought.
Yeah, we were unable to find anything.
It did say they may take things for safekeeping. It didn't say shall, it said may.
All I'm saying is talking to you a few days ago, it sounded like you were unhappy that they didn't tell you where it was. It was on their website and that's all
Yeah,
it
they
said.
couldn't point us to it. They couldn't give us a hard copy. They couldn't tell us where it
Said
was.
they didn't know it's online, so
Mhm.
we were unable to really find or define they were taking that situation. We're not against the sheriff's department. We're not anti-police or anything like that. We're just thinking this is overreach of something that shouldn't have been done. And if we're wrong, we have no problem backing down, but we just feel that there's something going on wrong here. That was, a lot of families set up these trusts to protect from all these things. I understand these guns are out laying around and, there's no safe or anything. I totally agree with them taking for safekeeping, or we wouldn't have been there. We're the only two in the trustees. She's the executor. We had all our ducks in order, and we just feel this is wrong. That's how we feel about this.
We're the only two,
And we're not
I'm the
fighting.
trustee, we're both listed in the trust. It was all right there. Everything was, our estate lawyer said she's been doing this for 25 years and never had a problem in any county or state that she's written a trust in.
And
This
my
is
wife
the
works-
first time
Yes.
our trust has been violated.
And so my wife works at a firm that does the similar type of litigation and talked to several of their attorneys in San Joaquin County, and they said they've never heard of anything quite like this either.
Thank you.
welcome.
Sorry for your loss.
Thank you.
You know, how much does it cost per gun roughly to recoup them, you know?
We're being told $80 to $100 a gun.
That's all hearsay. We're being told. We don't know factual what that is, so.
Okay.
That's, so. Thank you.
Is there any more questions?
What's the,
No?
I don't think the deputy had, whether he wanted to do it or not, he follows his orders from his
Yeah,
superiors.
exactly.
But was he
He made 3 phone
respectful
calls.
and
Yes,
compassionate?
They were compassionate. They
Yeah.
were, there was nothing rude about them. We'd like to make that clear to the sheriff's department. They were compassionate. It's just, I just got the impression he felt like we didn't want to be doing this either because of everything we had. So he kept calling us superior and was still told to do that. So we kind of felt like we were in a spot where we had to open the safe.
Well, I'd be the same way. You do what you're told.
He had the gun and the badge.
I say no, and they come out with a search warrant, and I don't know, it's just, you're not thinking clear during this time of, if that was a big concern, put a seal on the safe. You got one on the door, let's take this matter up on Monday. When we can get it all together, so let's not just start taking stuff. That's the reason for it, to put safe and secure where it was at.
And just a question, you are her only children, correct?
Yes.
Yes, we are.
I mean, it's one thing I understand if you have a family squabble,
Totally, we get that.
something like that, but you got a power of attorney,
We're both standing.
you got a trust.
And both of our spouses were there, and my son, there was 5 of us there.
Well, it doesn't matter, just who her relatives are.
We were all there.
On the other hand, a deputy's not a lawyer, his superior's usually not a lawyer. And for them to look at a document, it could be something that's totally fraudulent. They don't know. They don't have a law degree, and they're not the ones to discern who is the rightful heir.
I get that. So at that point, with everything stayed secured, it's not like we're not known in this county our name or anything. So we're not just some.
And it wasn't the scene of the death.
Wasn't even the scene of the death.
It's not matching us at all.
Could have been on Monday and just put.
And maybe the sheriff can address that when he,
Maybe so.
later on.
Thank you.
Okay, thank you.
Thank you.
My name is Tom Bamer. I have the same situation in my house. I have trust will. My 2 kids are the trustees after I die. I'm the only trustee right now. I want a way to leave a document in my house so that when a coroner comes, it tells them what to do with the property and keep their hands off as far as I'm concerned. Tells there's some stolen that there isn't. I'm really concerned about that. If the sheriff's department could help me, I'd like to have that done so I could do that, because I'm getting old now. I've already got old, but I might be quitting here one of these days, so I want to be sure that
Well, you could transfer the weapons to your children right now.
yes.
Keep one that for your protection and transfer all the others.
Maybe I could borrow one from her or something if I don't get arrested.
Thank you. Anybody's next?
This is just kind of ironic timing-wise, because I got involved with it with a gentleman I used to work with, lives up country. I'm just going to call him Mr. G.
Can you state your name, please?
Mike Blake,
Thank you.
unincorporated Jackson. And I just thought it was really kind of crazy because by the time the story got to me, it was a gun confiscation because an older man had died. Time went on, okay, left it alone. And then another gentleman, another Mr. G, whose daughter was a trustee, permanent resident at the place that he died. She had just finished giving CPR to her father, exhausted, distraught. A resident there, the trustee, and was told to open the safe. Guns were taken. Distributed, out-of-state guns were distributed where they should have been, but now she has to jump through hoops. I believe she has to drose all the guns, I'm not sure. But she's now got to get a real ID. Passport won't work, I don't know why. Even if it's expired, I got my last passport with my expired passport. She still hasn't received her guns. Upcountry, Mr. G has not received his guns, and we're working on about 4 months. And I heard the story of my dear friends, Dufresne's, and then my father just timely passed on Saturday. So he passed in Calaveras County, lives in Amador County. We're prepared, and have yet to, well, maybe I shouldn't have said that. But one of the questions I have is who makes the determination of valuable property? There could be a vase on the counter that's $5,000 vase that I think might have just been purchased at Walmart. Who makes the determination on what is valuable and what isn't? And then also, very respectfully, Sheriff Redmond, if property is secured and you only have 2 options, which is to seize it and then put a family who's going through a hard time through all the other stuff they have to deal with too. And the fact that you don't log weapons, if there's 40 or 50 of them.
Speak into the mic, please.
You should do your job. I can't not do my job because it's hard and time consuming and tedious. If you have to log 40 or 50 guns and give the person a receipt, do that. I'm sorry, there may be good reasons why you don't or you can't. I'd love to hear them. And then the other thing too, if the coroner takes possession and deems a place a crime scene, the best way you have to secure that scene is to put a piece of tape on it? Do your job, put a deputy there, protect the property, get the right person, whether it's a trust lawyer, a family member, next of kin, and get that property secured. Another question is, how hard do they try to notify all persons involved? Second, third, next of kin, trust, paperwork, okay, let's verify this paperwork. County has counsel, district attorney's an attorney. You know, it's Saturday, I'm sorry, if it happens on a Saturday, if you're gonna take responsibility of my property, who I own now that because of the trust, if you're gonna take that from me, you need to secure it in place. Confiscation is a very slippery slope, and this is where we're headed, in my opinion. And it just, there's just so many questions that need to be answered. It's been stated that this was the sheriff's policy by Gina, if that's on camera, if that's what your deputy's saying under advice from a superior. If it's policy, then you have the state law and you have the policy. Whose policy is it? Where is it written, and whose name is on it? That's just what, anyway, I don't want to take too much time.
Thank you.
Thank you.
Anybody next? Okay. At 3.
I'm John Gillick. And
Mind
my
signing
dad,
in, please, the sheet.
pardon,
Signing in with the sheet, please.
my dad passed away January 9th, and by the time I got to the house, the deputies were there and the firemen, and I had to haul my dad out because the road was washed out. And I came back with the deputies. They rode with me, and they said, well, we need to go into the house. And they took his prescriptions already. And I said, well, he doesn't own these houses. Well, this belonged to my sister and I. They already transferred over in our names a while back. And they said, well, it's our policy to go in and get the guns out. And so they had to go into the house that he didn't pass away in. We went into the house that the guns were in. They went in there, and they had all of his keys. They took all of his keys and everything. And I was asking him, what's this about? And he said, well, it's an investigation, which, they had mentioned. And I said, investigation on what? I go, is there a bullet hole in him? No. Is there strangle marks on his neck or a knot on his head or a knife wound or anything? They said, no. I go, what's there to investigate? He passed away, he's 89, he passed away of a heart attack. He had congested heart failure. I go, there isn't really a whole bunch to investigate here. Well, it's our policy, he said, and all this. And he went on, which is, he told me all about it. And we went in there, and he took my dad's keys and unlocked the cabinet and took the guns out. And that happened in January, like around the 9th. I've been trying to get them in my name for the DOJ, and it's been 5 months, and I've been calling them, and they keep putting me off and off and off. And basically, I want to ask is this: if it's just a policy, can I deny them entry into the house? That's what I'm asking, basically. I mean, do they have the? Can I just go ahead and do it?
I know that's a question. I don't know that answer, Sheriff. Can you answer that question? You're gonna have to come up forward. I'm sorry.
Question, sir. On the scene of a death, the coroner has the responsibility, and yes, we have access to where that decedent is. And when it comes to, the policies are on our website. But when you say it's quite obvious that your father died of a heart attack, I'm sorry, I'm not a doctor. I'm not a pathologist. You're not either. We have seen what looks like a natural cause, but based on toxicology that comes back, it's not a natural cause. It was either suicide from overtaking too many pills, or it was criminal acts. We have to look at every single one as a criminal act until proven otherwise. Because if we go in and say, look, there's an 89-year-old man that looks like he died from a heart attack, if that's what my deputies approach a death scene at, we're going to miss so much potential evidence of a potential crime. I am absolutely 100% sorry for your loss. I've been in the coroner for a long time, and the hardest aspect for me was having to, you know, support the families. It's a very difficult time. We want to make it as painless as possible, but we also have these safeguards in place to make sure that you do get your property. And it's not a seizure. This is a safeguard. We don't seize weapons like Mr. Blake said. It is a safeguard. DOJ changed the law. I don't agree with it. I don't like it, but it really doesn't matter what I like, because it is a shall do this as far as when it comes back to getting your firearms.
So I cannot deny them entry. I mean,
On a death investigation, no. We do not need a search warrant for a death investigation. Once we leave, if we have to try to come back and we've missed something, which is why we take medication, why we survey the scene and we do the things that we do, then yes, you can deny us entry at that point. Absolutely.
so even if he dies in another house, I still can't do it.
If there's a nexus of him living in this house and being part of that house, that is part of the death investigation. I don't know your particular circumstances, sir. I don't. So there's not gonna be enough information I'm probably gonna be able to tell you. I'd be happy to meet with you and talk to you about it. I understand there's a lot of people upset.
You see,
I get it.
well, 10 years ago, they never did this stuff.
The fact is, I've been here for 25 years, and yes, sir, we have.
Well, I know a lot of people have died. You got a lot of no's out there.
Yes, we have. The policy really hasn't changed with our office. And to say that I've somehow changed this policy is absolutely wrong. And I will 100% deny that, because this is exactly how I was trained as a coroner deputy in 1998 when I first got here, sir.
Because I know, I've been here since 1957, and I know there's been a lot of deaths that nothing was ever seized.
And it depends on the circumstances. There may have been a spouse there. We're not going to seize any property. We're not safeguard. Once again, we go back to this word seizure. There's a huge difference between safeguard and seizure. Safeguard is the people are going to get their property back. Seizure is when there's a criminal act and I seize that gun because you're precluded or it's stolen.
Sheriff, might I just ask one question? Why is it costing $80 to $100 per weapon?
So the penal code says it's a $20 fee from DOJ for the first weapon and $3 after. DOJ may tack on some additional fees. I don't know. We don't deal with the
So it's DOJ's fees, not your fees, or?
The fees have nothing to do with the sheriff's office. This whole process has nothing to do with the sheriff's office. And the fact that people keep saying all the other sheriff's offices aren't following this is an absolute lie, because they have to. And I know for a fact they are, because I talked to each individual sheriff personally.
To answer your question, this is just off the DOJ website. The $19 one-time fee for ownership transfer, however many firearms you have, $20 for a law enforcement lease, that's the background, and for one firearm, and $3 for each additional firearm after that. Again, this is off DOJ's website. This is not the sheriff's office collection.
Okay.
I'm more than happy to meet with you and make sure that you do get your property back, sir.
Yeah, the one thing I will say onto this is that I don't have a California Real ID, but I have my military Real ID. I can run through the airport and get through on the airline and all that stuff, because I have my military ID, but I can't buy a weapon with it. It's kind of wild.
The only thing I'm really worried about is they only gave me a 200-day period to get this done.
Mm-hmm.
And it's been 5 months now, and nothing has become of it. And I've been calling them and talking to DOJ, and I'm just really worried about losing them, because some of those were antique guns back in the 1800s.
The sheriff will not destroy anything without, coordinating with you. I know that much.
And I mean, I tried to talk to DOJ. I mean, I did this all myself. You can do it yourself.
Right.
And I asked them about it, and then they said, well, it's in process. And then I should have asked them this question: when you buy a firearm from a dealer, why does it only take 10 days? It's taken me over 5 months.
Right.
There's something going on here. I don't know what it is. I don't know that. I try to ask people answers for that, and they don't give me any.
We
I
deal
think-
with state agencies a lot, and pretty much all of them work on their own time schedule, not our time schedule or your time schedule. It's pretty pathetic that, they're not cognizant of people's time and efforts.
Well, I thank you, and I'm sorry for your
Oh,
loss.
I got one more.
Oh, sure.
They sealed everything up, which, you know, they were doing what he said.
Mm-hmm.
And, I never did get a receipt for my gun, so 7 days later, my sister, she's been working for the sheriff department in San Luis for 40 years. She was with me. We came to the sheriff department to get his keys, his wallet, and whatever he had on him.
Mm-hmm.
And we were getting ready to quit. I told the gal in there, I think it was Amy, might have been her, I go, when you take someone's property like that, you should give a receipt. And they looked at me like, you didn't get a receipt? And there was only 7 guns. I said, no. And, they went and got me a list of all.
Okay, so you have a receipt
Yeah,
now.
I did get a receipt.
Okay, thank you.
Okay.
Excuse me, folks, let some of the other people, we had some other people in the back that wanted to come forward. Yeah, you'll still.
Sorry, I have a long last name. Patty Fisher, Mizoraka, unincorporated, I own. I have a lot of questions about this because, just due to the fact that I've been hearing about this, law. I'd never heard of it, just like everyone else in the room, I think. Never, ever heard of this law. I lost my mother in the home. I lost my father. And so I didn't see that things were being practiced equally. And so my concern is, I'm a law-abiding citizen. I completely support our Amador County Sheriff. We probably have some of the best sheriffs in the state of California, and I truly believe that. But I think what we've got going here is, it just seems like we're opening up this county for a big old lawsuit if it's not the same. And so my question is, I was reading the law because I could never find the law like anybody else. So I started reading it when the officer gave us the code number. And it does say may, and it says valuables. It doesn't say firearms. So I'm wondering, where did this become firearms? Because I'm not a gun wielder. I've never even shot a gun before, folks. But I have a lot of antiques, like Blake said, in my home. So when and where do you draw that line? I like Tommy Bamert's idea of coming up with a form rather than spending $3,000, which I did on a trust for my 2 boys when my husband and I kicked the bucket. I'd much rather have a form like Tommy's saying that's right there, posted on the door, that says, boom, this is what happens. And maybe that's what needs to happen. This is penal code. This isn't, I know penal code is law, but it's got to be practiced equitably with everyone. You can't. I just think the county's opening themselves up for a big old lawsuit if these officers aren't trained to deal with it equally in all these situations.
Thank you. Morning.
Sorry for you guys' loss. I've known the Dufresne family, Gene and Mark. Gene was a sergeant of mine at Preston. I worked there 22 years. I'm going to tell you a little story about what can happen and the way things used to happen. I'm an only child. Mom was 42 when I was born. My dad was 43. Had health issues, heart surgery, strokes. On my birthday, and they didn't mean to, they didn't probably even know what day of the week it was. They were both sick and ill. They committed double suicide. I didn't know about it. The neighbor found them the next day. They called Preston. They didn't know who she was. The sergeant called me. I went to the house. Neighbor lady's out front. I called 911. everybody shows up. Get me across the street. It's on TV. They got the whole street taped off. Well, question, do you know there's guns in the house? Yeah, there's guns in the house. I've been hunting and fishing with my dad since I was knee-high. A gun's here, a gun's there. They didn't have no gun safe, okay? At first, they said murder-suicide. I looked in the bedroom. I actually didn't go in there. I was distraught, you know. So they come back 3 hours later or so with a suicide note. As we got older, we knew something might happen. They took the 2 firearms, the 2 pistols. One was a 22, and one was a 38 or so. They take those. They didn't take any other guns in the house. Not a one. There was half a dozen shotguns, rifles, whatever. Not a one. And that was over 25 years ago. Okay. I get to leave the house. I go, oh man, take my folks out of the house. My thought wasn't the guns. I go in and get all the banking records because it's on TV. It's on Channel 3 TV. God, everybody can see what happened in Sacramento. And Sacramento back then, well, they lived in a pretty good area. So I'm thinking, when did this policy start? Obviously, this was in Sacramento County. They have a lot more incidents of crime all across the county. It's a big county. They didn't seize guns back then. As a matter of fact, a friend of mine that helped me through the whole process with coroner's office, sheriff's office, all that stuff, he goes, what are you going to do with those guns? I go, what guns? He goes, the guns they used. I said, well, I don't want them. He retired from Preston. He was moving to Texas. I go, you want them? I go, I don't want to see them. I went out to a place off of Bradshaw, walked in, told the officer, I want these 2 guns. I showed him my ID. Tom went in, put them in a briefcase. I never saw the guns again. I didn't want to see the guns. But why destroy them? They didn't do anything to you. And he liked having firearms or whatever. So my confusion is, going into somebody's house in a secure safe and taking them. I have a safe. I know lots of my friends have safes. I don't know how somebody would get it in the house, get it out of the house. It took 10 of us to put it in there 30 years ago, whatever it was. I feel bad for that people. I know, I mean, I'm still kind of shook up over my folks' death. It took me 25 plus years to get over it. And have somebody come in there, oh, we need to get your guns? My thing was, okay, if you're worried about the guns being in the safe, can you call somebody? Do you have a safe in your house? Categorize them, you take them with you today, the property's safe. I don't know where all this comes from. We have to go in and take them. Maybe it is their policy. You know what? This is the first time living in this county. I used to work for the Department of Forestry as a fireman, and I worked 20 some odd years as a youth correctional officer at Preston. I've never heard of this. And you know what? I don't know what the answer is, but to me, the policy needs to be changed. And I'm pro law enforcement. I love Ion Cops. I love Amador County Sheriff. I love CHP, especially on crazy weekends out there by Comanche, all the drunks and stuff. You know, I support them. To me, this is wrong. Policy, law, whatever you want to call it, needs to be changed so it's a lot more equitable for situations like this. Thank you.
Thank you.
My name is Charles Huffman. I guess, I live here in Jackson. I guess this all started at my house. I was taking care of her from the manor every day. Brought her over on that day. She felt fine. She told me she had a bad pain. I called the 911. They responded. They did their jobs. I had 3 different fire departments there, plus the ambulance people. And what I'm talking about is when the deputy came in to take the coroner's report, why he didn't ask if she was on medication or not. But he proceeded to cut her clothes off, take a frontal view with the camera, roll her over on her back, on her front, and took a back view. And this was not a crime scene, this is where they called a crime scene. I'd like to see the policy change that they don't have to take a crime scene photo of a person that died either from heart failure or whatever, because I haven't seen the report yet. But she had a bad heart, she couldn't walk more than 15 feet without help, and she was on oxygen, so.
Mr.
Main
Huffman?
thing I'd like to see,
Oh, sorry, I thought you were down. I'm sorry.
she was on oxygen. She carried a portable oxygen everywhere we went. What I'd like to see is that they don't need to take a picture of her, because we had, like I said, 3 different fire departments and the ambulance people there, and the Jackson Police. So I don't know why the policy is to strip her down, take frontal views, and take a back view. That's all I have to say. I'd like to see the policy changed.
Mr. Huffman, was she under doctor's care, seen a doctor recently?
She was under 3 doctors, a heart doctor, a cancer doctor, and her primary doctor for a stomach problem. And the next Friday, we was going down to see her primary doctor for her stomach problem.
Thank you.
And also, they just had a week before, she had a talk with her cancer doctor. She's from Sacramento. And they did it by, I guess you call it Zoom. And she was at the Manor, excuse me. She was at the Manor, and they talked to her. So she was, within a week, she had seen a doctor. I couldn't see why they had to cut her clothes off and take the pictures. Thank you.
Sorry for your loss. Thank you. Anybody else? Okay, come on forward.
My name's Mark Dufresne again, it's my sister Gina. So, well, real quick while I'm thinking, I just had a question for, I guess would actually be a question for the sheriff. If my mother would have gotten the ambulance and they took her to the hospital and died in the hospital, would this still happen? Would they still seize guns? I'm just curious about that question.
Yes.
If they would, they do? Okay, so we just wanted that question, because their policy was, we read, kind of varied in different things, kind of little contradictions in them. And then Gina can handle what she thought to, why we want to move the guns to a federal firearms person to speed the process up.
The cost for DOJ, they're correct on, but as the other gentleman said, it's taken him over 5 months. Some people we've heard are over a year now. If you go through that process, if you go through a licensed firearm dealer and pay the cost per gun, $80 to $100 per gun, then they are under the 10 days. The sheriff's office is supposedly not under the 10-day limit, but the firearms dealer is under the 10-day. So it will speed up the process, and we won't have to worry about our guns being
so there's a secondary method to get them quicker. We were just explained that since these licensed firearms, they're this time period, the DOJ has to honor that.
Right.
They don't have to honor it with the sheriff's office. Nothing against the sheriff's office, they just don't have to honor it with them. So they're kind of on the back burner. So there is a process to do that a little faster. And also I asked,
but it costs money.
I was concerned, I've heard stories, I know hearsay, that there's a lot of firearms to be confiscated. Where are they storing all these firearms? Are they all in the evidence locker? I heard there was.
They're all in the evidence locker. They're all in all those sitting in the jail.
I heard there was a secondary secured spot, and I was later told it was a hangar at the airport. And so is this thing controlled for the guns, because the person supposedly got their guns back rusted and scratched, and most of them were unfired, brand new. And I do not want them in a hangar somewhere at the airport, if that's true.
I don't know.
I'm just saying that that's what's concerning us about moving these to speed the process, which we probably will do to do it. But just so other people know there's an alternative, it's going to cost you, but at least you get your guns back. So just some information for people.
Thank you.
There were several questions posed. Could you just restate the question, please?
If my mom was died, like in the hospital, or
Maybe Mark, maybe
Come to the second microphone there.
If my mom would have died in the hospital or in Oak Manor, does that make a difference of them? Because we've been told different stories, so we just want answers.
It does make a difference.
It does,
It
okay.
does make a difference. At Oak Manor, it may have been an attended death and a non-coroner's case, a non-reportable death to the coroner. I don't know the answer to that. I don't know the medical condition. At the hospital, it just depends on the situation. If, the deputy felt the need to go and secure a residence for a death at the hospital that was going to be a coroner's case, he could go to the house and secure the house. It just depends on circumstances. I know we can change the story a bunch. It just depends on the circumstances. And the only thing I don't know the answer to is, and I don't think my person in charge of the evidence room knows the answer to, I don't know anything about transferring the firearms to an FFL. I don't have the answer for you, but you can certainly contact me and I'll look into it.
I think we can, well, yeah, we're looking into.
I don't know the answer.
Yeah, that's fine.
Is there any way that we can look into that, you know, for,
I'll talk to them. I don't know the answer. I've never had
I know if we can get, DMV at AAA, you know, we can do anything.
There were a couple other questions. One of them was, definition of valuables. I mean, lots of things are considered valuables. How does the sheriff's office, go through the process of determination of what is a valuable?
I don't think you could not classify a firearm as a valuable if there wasn't so many people here talking about it right now to make a statement. The other thing is, I don't know the difference between a Ming Dynasty vase and a Walmart vase. That would be have to be something that would be obvious to the deputy coroner that was on scene. Cash, jewelry, whether it's costume jewelry or real jewelry, or those are the types of things that would be taken.
It's pretty normal for, I'm not saying it's, not traumatic for the family or loved ones, but pretty normal for the coroner's office to have to take pictures of the deceased?
Yes, we're required to take pictures of the deceased. And just to be clear on this, we have a one-time bite of the apple on a death investigation. When we're on scene, and we have a right to be on scene, we will collect the evidence that we're able to collect while we're on scene. Once we leave that scene, it requires us a search warrant to get that evidence, if you will. So we will do our due diligence when we have the ability to be on scene.
Do you know if the weapons can be processed through a local firearms dealer or not?
No, sir. I've never heard that before. I don't know the answer to it.
Can the sheriff's office facilitate the process, like with the one gentleman who it's been 5 months and still not getting an answer?
My investigations lieutenant is, I believe, familiar with that case and is speaking to him in the hallway right now.
Okay, thank you.
You know, one thing I'd like to see looked at, California Penal Code says sees. I would like the sheriff's office to consider if you have surviving heirs that have what appears to be pretty good color title, that they honor that. And one more thing I'd like to also, I think Mr. Redmond took great offense to, that I was accusing his officers of embezzlement, or possibly. That is not what I was doing.
Wouldn't be embezzlement, it'd be theft.
Theft, whatever, how you want to look at it. Okay. Personally, on a personal basis, and on a governmental basis, I try not to put people in positions they should not be put. I don't like being put in that position myself where you can be tempted. And all I'm looking at is not Amador County law enforcement deputies or administration. I'm just looking at reality. It happens. We had a lady was part of Amador County, what was she? Adult Protective Services, I think. We never did, it happened before my time here, not saying I'm innocent of it, but it's something just, I wasn't involved. It happened to anybody. I don't remember how much money she stole, or if the county ever figured out how much money she stole from people under county's care. I think it's probably $500,000, maybe more. So it does happen. And if I go at Google, there's all kinds of them here where, you know, officer sentenced to jail for 1 year for embezzlement. There's embezzlement, there's all kinds of them. It happens. So I want to make it clear, I'm not accusing any of our law enforcement personnel of theft. I'm just saying it happens. I would like to see our policy changed to where if you go and take guns, you take a photo record, that'd be fine. You're not putting that officer in a position that I'd rather see him not placed in. That's all I'm saying. I'm not saying they did. I'm not saying they're going to. Just this way here, hey, we go to the house, we pick up the cell phone, we take a picture, there it is. There's the record. And tell the people, here's a record. This is what we took. I don't see anything wrong with making that request.
I'm under the microphone right there in front of you.
Just when I talked about this, about the situation that the deputy was in, I mean, we're all okay people. There were 5 of us in the house. And there was 1 deputy. So, and he was good. I think, I don't know, I felt he was in a safe situation if we had been 5 different people doing this. Because we were back in a back room, no exits, and I got thinking, what if we were nutcases or something? And maybe there should be 2 people. And I don't know if that's kind of a policy for it, you know, it's like, maybe they need to be safe too. You know, we're not here, we're here because of questions for the sheriff's department. I also would like to make sure they're safe in a situation like this. Like maybe there should be 2, and I really believe we should have a receipt when they leave, when the guns and valuables leave at that point. I've talked to friends in the police department, they say they have to do a receipt when they take things that time. So it's just a suggestion that maybe there would be 2 deputies when there's firearms involved here. You know, you're opening a safe, he's standing behind me. I mean, you don't know some people. You just don't know. You know that. Maybe it would be a little better. There's actually 2, and there's just more people there and a little safer for everybody. And maybe the receipt would be a good idea when these weapons are taken out. It would make us feel a little more comfortable. We did make one, and we did it okay, but still, just some positive input for all this too for everybody.
Thank you.
Thank you.
I see we have one person on Zoom.
Thank you, Mr. Chairman. I thought that there was one member in the audience who was waiting to get up and speak.
Questions for me, gentlemen?
Not just yet. Might as well sit in the front row, though.
Good morning. Don Kleinfelter, originally from Jackson.
Morning.
Living in Plymouth. I'm familiar with a couple of cases where firearms were seized. One was like Mark's. 2 daughters were on scene. The man died in his home, lived alone. So a lot of my questions have been answered today. Why they seize property and seal the place. They had trust paperwork in hand. Why can't the deputies, or the sergeant in that case, honor that trust paperwork? I mean, everybody knows a trust is an entity. They now own the property that's in that house. They're not saving anybody from stealing anything. It doesn't make sense.
I think that's a question, Mr. Kleinfelter, exactly.
It's common knowledge what a trust is. Deputy does not have to be an expert. He can look at a legal document and say, this looks real. It's got a raised seal on it. And then, second case, the man died outside the home. Deputies came, seized weapons. The wife let him in. Surviving spouse community property. Nobody's addressed the community property issue.
Well, they did. They're not supposed to, I mean, I've seen that in myself.
I didn't hear anybody.
Yeah, they're not gonna seize it as a spouse is in the home, they're not gonna seize the property.
Well, they did. They took weapons. Turns into a DOJ issue. I'm not sure how DOJ, maybe they're required to get notified. So now those weapons that were not required to be registered in the past because of their age, they were obtained prior to the law coming into effect, now have to be registered, and that's where the high cost comes. The cost that was bannered around here in the room was a lot more than those two daughters had to pay. They were $48.50 a weapon, and there was a lot of weapons. They had to put out a lot of money to get their weapons back. Their property.
Right, understand.
It was seized at the time of the death. Did you have an answer to one of my questions?
You gotta come to the microphone.
Possibly. I want to answer your question. There are two different storage locations. One of those are for adjudicated guns. That means that we're going to destroy them. Or the other one is for guns in this situation where the case has not been adjudicated or a rightful owner has not been determined. That location is at the sheriff's office.
So our guns will stay there.
They will stay there. They're in hangars, if you will, hanging bags on a racking system inside the evidence room.
I was worried about this.
And Joe, I just want to make this clear. In the situation of us or a deputy sheriff making a determination of a valid will or trust at the scene of a death investigation. In one of the situations, it was on a cell phone. And my deputies are not going to look at a cell phone and look at a document off a cell phone or a copy of a document and determine the validity. That should be done by my chief deputy coroner or sometimes county counsel, not at the scene of the death. And I think that the fastest way for this county to spend money is for my deputies to release property to somebody who is not the rightful owner of it, and we didn't do our due diligence to determine who that rightful property owner was.
If that's the case, Under Sheriff Middleton, why couldn't you just seal up the house for a couple of days and sort that out and save people a lot of grief?
We did seal the house.
And leave everything in it.
I beg your pardon, sir?
Seal the house, leave everything in it for a couple of days, sort out who the rightful owners are, say, there's your house, there's the contents, have a nice day. I think that'd lessen a lot of pain.
And I'm at fault if something is stolen.
How are you at fault?
Because I left that property there. I didn't care for that property that was valuable, like the government code instructs me to do.
Government code says may.
Yes, it does.
I don't see how you'd be at fault.
Haven't been to court.
Pardon?
You haven't been to court then.
The case where this gentleman just described where a spouse was present and the firearms were safeguarded, do you have any?
I don't know where this was at. I don't know what year this was. I don't know what the name of the person was. I don't know the answer.
I can't give you any other information.
Yep.
I was asked not to.
Okay.
Okay, let's go on to the next. Thank you.
Thank you.
Under Sheriff Middleton.
Thank you.
Thank you, sir.
Thank you.
Do we have any more in the audience? Yes, sir. Need to speed this up, unfortunately.
We're all here for a reason. I understand that the sheriff's under constraints by the states of laws of the states of California, and some may be unclear and we don't know. So we're all here today not only to try and resolve the problems that we have right now, but to see what we can do to prevent them in the future. Now, whether that's a policy change with whether I may consider this valuable, so if I do, then am I gonna be responsible for it, or am I gonna try and resolve the issue with the citizens that pay your wages and find the rightful owner in 24 hours, maybe? So if you're gonna have to either seize somebody's property or be responsible for it, then be responsible for it. Now, I don't know if that's something that can be resolved by you guys, just making it simple. Okay, if I'm gonna think about taking this, rather than just take it, okay, boom. Okay, hold on. My county has an ordinance that if this situation comes, the sheriff must do their due diligence, whether it's by county council or somebody, to notify the rightful owners, give them 24 hours. Hey, in 24 hours, we're gonna pull an officer out of here and take the stuff and leave it sealed. Or, I mean, we pay taxes for a reason. I mean, sometimes people live out of state, you know, and as for, it didn't happen to me last week, thank God. But that's our deal. What can the sheriff do to help us out? What can you guys do to give him the tools to help us out?
Well, right now, I think you're making some statements that I'm not sure they're 100% correct. I had an individual in Iowa whose father just passed less than a week ago. His sister was the trustee and in charge of the estate. In less than a week, her documents were verified and they were allowed to go back in the house and go through all of the property.
But they didn't take any property out of the house.
Doesn't matter. They didn't have access to the safe at that time. So that was the difference.
Well, how does that go then?
I'm just saying,
Well,
it's
yeah, it
timely.
goes to Mark's
It's
question.
timely the way it's happening right now, if the person provides the documentation.
Okay, so what if Mark would have just absolutely said, you are not getting into that safe? I'm not opening that safe for you. What are the repercussions of that?
Don't know. It depends on the answer that's given. If he would have said, I don't have access to the safe, then the safe would stay there.
A lie, Sheriff's Department. I'm brought up there now. What if I just said, I'm not opening it? I don't feel comfortable with it. What would have happened? So I was coerced, I feel, by, we have to do this is policy, and so I'm just feeling in a vulnerable moment that we got pushed into opening this, so that's why I wanted to, because I asked the guy, what if I refuse to open this, and really didn't get an answer back from it at that point.
This topic was actually covered early on. Supervisor Forrester asked the question. I don't know what's in the safe. If the safe is locked, I don't know what's in the safe. If you don't have the combination of the safe, I don't have a way of finding out what's in the safe.
Okay. The question we've talked about was, and I talked to that same person too, they asked about firearms and he said they were secured in that safe. So I'm under the impression.
That individual told me that he told the officers he did not have access to the safe.
But he told me that and he told me, so this was firsthand from him, that they said, okay, the firearms are in the safe, they're secure. So that's the conversation I had with him. I'm not gonna bring up people's names.
Yeah,
If he was comfortable with me doing it, but I'm not going to.
My conversation was,
I'm gonna respect that.
my conversation was a hair different, where firearms never came up in the discussion.
And the same I had, that he never
Yeah.
told me they didn't have mine.
All right.
So there are some different things going on here. I mean, we're not attacking you. I don't want you to feel like that. We just feel that this shouldn't happen to us with trust and everything, that maybe just, since you can't verify a legal document, we have a very good safe there. You could maybe, somebody looking at this, somebody's walking in here with not one person's walking out with this safe. Let's deal with this Monday. Put a green seal on the safe. We got one on the house. I'm not sure all that had to be done because she didn't die there, but if something to where starting something in motion we can't change now, maybe just wait until Monday when we could have.
Well, I like what Mr. Bamer, former Supervisor Bamer, suggested, is maybe have the document on file with the Sheriff's Department.
Possible, yeah.
Mike?
Okay.
I don't need any commentary from the...
You know, one thing I'd like to look into. Once again, 2 days ago, I talked to Sheriff DeAugustini, former Sheriff, El Dorado County. He told me that is not how they always do it over there. I think it's rarely, as I recall. I'm going to contact him, If he will, I'm gonna get something from him.
But he's not an active sheriff.
How they did it when he was
He's not an
sheriff.
active sheriff right at this time.
I understand that. I wanna know how they did it, and that's something I'd like to look at, 'cause they can.
But no, we
if
need
it
to
can be-
find
Hold
out.
on, hold on, Jeff, Mr. Chairman. If they can do it there, not have to seize all the guns, why can't we do it here, be my question, and that's something I want.
The question you need to talk, not to an older sheriff, you need to talk to what the current sheriff is. What the current sheriff for El Dorado County, what the current sheriff for Calaveras County, what the current sheriff in Tuolumne County is doing.
No, the code is 2019,
I understand.
government code. That's
But
what
we
was put in
need to
place.
do what is
Current.
being currently done through all the counties. Not make it, this special.
I don't agree with that at all.
Okay, I appreciate that.
Sir, do you have any further questions for me?
Well, let me find out what we have. One person on Zoom with a raised hand, so let me get that one through. I need to get this wrapped up.
Thank you, Ms. Moreno. Go ahead when ready.
Good morning, Mr. Chairman and County Supervisors. My name is Stephanie Moreno, and I'm a resident of District 5 and a former Amador County Supervisor. My ex-husband, Tony DiAgostini, was under a doctor's care and died at home from natural causes a few days after being released from the hospital in October of 2021. The friend who found him called 911 and then the family. First on scene were the first responders, then our family, then the sheriff's deputies. There was no indication that Tony had died from anything other than natural causes, and the sheriff coroner chose not to perform an autopsy. When the deputies arrived, they began searching the entirety of the house, accessing his gun safe, opening drawers, and going through closets looking for guns and cash. We questioned them when we saw them removing the guns and putting them in their vehicles, and they said that they had an obligation to ensure that the property was turned over to the rightful heirs. There was no mention of the need to secure property because it was an active criminal investigation, even though they now state that as their justification for the removal of the property. We told the deputies that the only two legal heirs were present, and they responded that we needed to prove that. I told them that the signed and notarized trust and will were in the house, but they refused to allow me to go in to get them. I then told them I had copies at my home 10 minutes away and could go get them, but they said they couldn't wait for me to do that. They took less than 40 guns, his entire wallet, approximately $5,000 in cash, and the keys to the house and vehicles. We did not see them take photographs of the guns themselves on scene, and they refused to provide a receipt for any of the property that they took. The sheriff subsequently told me it is his policy to have the deputies not issue receipts on scene, as it is not safe for them to remain on scene to do so. The wallet, keys, and cash were returned days later to my daughters after we provided the sheriff's office with the same trust that we offered to provide on scene. We have no way of knowing if all of the guns that were taken from the family home were included in the inventory subsequently provided to my daughters. One of the guns the deputies took was registered to me in my name. So I'm not sure the advice just given to former Supervisor Baymert about transferring ownership to his sons would protect him. In order to have the guns returned, all of the guns were required to be registered in one of my daughter's names. The registration had to be resubmitted for some of the guns because the sheriff's office recorded an incorrect type or serial number on the forms for my daughter to sign. Ultimately, it took over a year to get all but one of the guns returned. The one they still have, they are refusing to release because they claim it was stolen in the 1980s, but the report doesn't appear in the DOJ database. And DOJ has notified both them and my daughter that the sheriff's office does not have a legal right to not release the gun back to her. They are saying it's a civil matter now. However, the sheriff's office is attempting to get her to sign papers releasing the gun back to them nevertheless. When my father died in 2012 on hospice, the deputies showed up and asked if the family had any guns or cash. They didn't ask if they had any valuables, just guns or cash. At least twice that I am aware of, sheriff deputies have gone to a decedent's home and demanded guns from family members after the loved ones died in an auto accident. We do not know how many other families have had their guns removed, and how many of those guns were never returned to the rightful heirs. And it is a significant difference in response to one of the statements made that if the guns are taken rather than sealed on site, because if they're sealed on site, the sheriff doesn't take possession and then the heirs don't have to re-register the guns. I think Supervisor Oneto's suggestion to secure the site rather than taking the property is a reasonable option. Families should not be forced to deal with this kind of treatment on the day their loved one has died. There's no reason to secure property when the family is on scene of a natural death. If anything, that is incurring additional potential liability for the county. Although I recognize the sheriff is an elected official and the board does not have authority over him, I'm asking the board to do what it can to help restore common sense and accountability in these already traumatic situations. One option might be to hire an independent reviewer from outside of the county to review the policies and procedures and make recommendations regarding the future removal of property from a decedent's home after a natural accidental death. Thank you.
Okay, thank you. Anybody else on Zoom?
Not at this time.
Okay, we're gonna take a quick break, and then we will go on to the 10:30 hearing. Okay, we're gonna be bringing this meeting back to order. Okay, we're going on to, unfortunately, a time certain item of 10:30, but we'll keep on going. Board of Supervisors discussion and possible action relative to the current condition of the roadway system, priority for repair, and other potential solutions for improving the aging and deteriorating system, and gaining input from the public regarding the issue. We had a PowerPoint presentation from our road people. Chuck, can you put that on from Rich, PowerPoint? And bring it to page 6. I'll just get started with this as the PowerPoint presentation is starting. On a typical year of expenditures for roads is about between our SB1 money, our other gas tax money, and a little bit from the county is roughly $6.7 million. Of that $6.7 million, 2.9, roughly 43% is for salary and benefits of the staff of the road department. 1.4 is services, supplies and services. 1% is outside services, and then 2.3 is SB1 items, and those are dig outs. I'll get to that right quick because I can read it. Dig outs, striping, culverts, crack filling, minor repairs, roadside maintenance, and set aside for tools and equipment. So part of my investigation on this is we should be replacing probably 13 to 20 miles of roads a year in this county, but at the current progress, we're doing about 2. And even this 2 that we're doing right now, the 3 miles that we're doing right now in Shenandoah, is because we had extra PG&E money that was given to us, and so we were using that money for the roads, any of the funding that we could find. We had some ARPA funds, we put some of that money into it. So our current budget for this next year is almost $18 million. Part of that is also grants as far as bridge and bridge funding, and our Pine Grove Improvement Project is all part of that. And that's money that's been saved up for the last, 10 years? 10 years to get that, that funding for that. So it's all coming to fruition. So really the $6.7 million, but we need about another $6.7 million to do this annually, to continue this. I've had on social media complaining about the Board of Supervisors are overpaid. I always love that one. Even though we've given every employee in the place their standard barely pay raises, 2% here and there. Our sheriff's department is our law enforcement is our biggest employees of the county. So all of this is a big thing that we're trying to adapt and overcome, and that's one of the things that we brought this meeting to hear, is to listen to you and see what your thoughts are. One of our thoughts as county supervisors is a 0.5-cent sales tax to be put on, just like we do for fire right now, Measure M. That's been one of the items that have been brought up to the board. We're working on, I know we're also working on the assessment. But any other thoughts on it? And anybody want to come talk to the Board of Supervisors? It's your time. Please.
My name is Andy Azaretto. I've been a resident in Amador County.
You wouldn't mind signing in too? Should be a sheet to the right there.
Oh, this sheet right here?
Yeah, thank you.
I'll repeat, my name is Andy Azaretto. I've been a resident in Amador County over 40 years now. I live up off of Shake Ridge, kind of where Fiddletown Road comes in. I've been in my current residence for 33 years. I've been driving up and down Fiddletown Road and also Shake Ridge Road quite a bit. And we all know, we don't have to even talk about it, the roads are in horrible shape. But I have a couple questions that I have to ask the board members. So Supervisor Crew, you were in business here in Jackson for a long time, right? Jackson Tire, is that correct?
Correct.
Did you have equipment at Jackson Tire, like tire changers and stuff that you use day in and day out?
Sure.
Okay, did you maintain that equipment? I mean, or did you just use it till it ran into the ground, was broken, and threw it away? Or did you have a maintenance program for that equipment?
Well, there's a certain amount of maintenance you can do, sure.
Thank you. Supervisor Onetto, you're in the timber business, correct?
Yeah.
Do you have equipment, trucks, chainsaws, loaders?
Sure.
Do you maintain that equipment?
That's a yes and a no. I maintain,
No.
I maintain.
Yes or no answer, one or the other. Yes or no. We're not talking in circles here. It's a yes or no answer. Do you maintain your equipment on a regular basis?
Andy, it's not a yes or no answer. Do I do normal maintenance, greasing, replacing wear parts? Yes. Do I maintain it the way I'd like to? No, because I don't have enough money to maintain that equipment.
Fine.
Like it should be. So some stuff is patched up.
Correct. So Supervisor Brown was one of the few supervisors, other than Supervisor Crew, that responded to my emails, and he told me that currently there is no comprehensive maintenance program for our roads in Amador County. And from my own experience and what I've seen driving up and down these roads is about 70% of the problems with our roads, especially this last winter, was caused by water running up on the roads because the culverts and ditches are not maintained. And I think simple maintenance, very simple maintenance, cleaning the ditches, cleaning the culverts, keeping the water off the road would save the taxpayers of Amador County millions of dollars a year. But for whatever reason, and I don't know why, there's not a maintenance program in place.
Okay, now we may have had a little bit of a, per our conversations, you asked about a maintenance program. I'm thinking as replacing roads as far as that maintenance, as our per our conversations that we had before. Now, we do have a maintenance to replace or clear an amount of culverts in the county every year. And that's part of our budget is to do that every year. So that is being done.
Okay, well, we have 5 minutes.
I'd like to address that a little bit.
Excuse me. We have 5 months till winter starts again.
Understand?
1st of November is when we usually start getting our weather, okay? I have seen nothing being done on Shake Ridge Road or Fiddletown Road. I drive those roads a couple times every day, every week, week in and week out. Nothing's being done on those roads.
We just cleared snow out of the last couple county roads up in the high country. So the guys have been working, doing stuff.
Correct, but nothing's being done on our roads where we drive up and down every day. I mean, this building looks very well maintained. Does the maintenance program stop at the doors downstairs? Is that what's happening in this county? The simple maintenance program would have saved the taxpayers millions and millions of dollars over the years.
Mr. Azaretto, we do regular ditching. We can provide you with what the road crews are doing. We have 2 crews, I believe. That's it.
I've lived on my street 33 years. I've never cleaned a ditch on my road.
Well, we can get you hard copies of everything that's being done as far as ditching and culvert clearing.
Andy, do you want to hear
That's happening. There is a pavement management system that we have. That's a software program, and that was, brought up to date maybe 6 to 8 years ago. But you need funding to do that work.
Correct.
That's the problem.
You want to hear the rest of the story or not?
What story is that?
You're right.
Correct.
I've been in Public Works' rear pretty hard. Last year, even before that, the previous Public Works director saying, hey, we're not cleaning your ditches. They didn't get clean. So a new guy came on board, and I think he's doing better and better and better. I said, we need to clean our ditches. Many times I told him that. Last year, I was on his case real hard. I said, hey, we need to clean our ditches. Well, the road crew is busy doing a lot of stuff. They don't have time. I said, we need to clean our ditches. We're going to be cleaning our ditches. And he says one time, I said, well, how much? 2 weeks. I think it was a week or 2 weeks. I said, you can't do our ditches in 2 weeks.
It's not being done up where I live at all.
I said, no, hold on. I said, we need to hire a private contractor and put a contract out to help the road crew. And he was working through the details, didn't get through them. They don't have a lot of staff down there, so I'm not throwing all at him. But you're right, our ditches didn't get cleaned. It hurt our roads. And you look in some of the roads, there's trees 6, 8 feet tall. That tells you ditches aren't being cleaned. So I think you're 100% right. This year, though, we did get some more money. I think we had some, can't remember where it came from. I think we put about $300,000 towards ditching and doing the shoulders. So,
But this is
right.
one-time money, remember that.
But it needs to be done.
I'll close with this statement. A few of you in this room know who I am, most of you don't. Well, for over the last 20 years, I've been pretty involved. I work with mules. I train mules, ride mules. I've never owned a horse. I never will own a horse. Mules are very intelligent animals. And one thing I've noticed between a mule and a human being is a human being will keep doing the same thing over and over and over again with the same results. A mule, not so much. Once, twice, the third time, you better start figuring something out because it ain't going to work with him. So this Board of Supervisors here needs to figure something else out on how to finance our road repair and get it under control before it's too late, because it might already be. Thank you.
Hey, do we have anybody else that's come forward?
It's still morning. Good morning.
Yes, good morning.
Jen Houghton, Pine Grove. Two things. Gary Reinhold couldn't be here today, but he did send a letter in a couple of days ago.
And I have it.
Okay, so we'd like that entered into the record.
Okay.
Secondly, I know it's anathema to most citizens of this county to envision any tax increase propositions that are made. However, I think a 1/2 cent sales tax to improve the roads is very reasonable. We need the money to do the roads. We all need to take responsibility for it. Everybody's at fault. Everybody can be part of the solution. And I think a 1/2 cent sales tax is certainly reasonable. And I hope it's proposed, and I hope it will go through. And I know it's going to take a lot of animosity and all that sort of thing, but I think it's the right thing to do. Thank you.
Jen, the one thing is, as if we put a 1/2 cent sales tax, that's the one thing we want to educate, is that the board can't spend any money to promote that. So it's going to take outside agencies, as in yourself, to do that. So that's one thing we're asking is if we decide to go that direction, that it will take outside effort to assist us. You know, and that's just something
That's reasonable.
to put into that.
Kind of champion it, get the word out.
Because that's the one thing that the board cannot do is spend any money to promote it or do any of that, you know, that part of it.
Okay,
Thank you.
thank you.
Bill May. I don't know if there's anybody been more aggressive toward getting this board to set up a public hearing. I have railed on you in public comments. I've written letters to the editor. I am absolutely delighted that this day has finally come and we do have a discussion. And I, for one, would say that if you put the half cent sales tax on the ballot and you say it's dedicated solely and only for fixing roads, I'm all for it and I'll vote for it. And I will encourage through letters to the editor, whatever else it takes, everybody else in this county to vote for it because these roads need fixing. Thank you.
Bill, as one of our champions and where we're going with this, the one thing that we need to also remind everybody is that if we do a half cent sales tax, it has to be split just like Measure M with all the cities. So that it would not be just the county, it would be the county and the cities, and it would have to be split just like Measure M type of thing. So we'd have to figure out that formula too.
Are you sure, Jeff? Because that was a question that I had.
Well, you don't have to. The county can go it alone too, but
yes,
okay,
it would be a benefit to the other jurisdictions to go together. And I believe someone from CSAC is going to also come and talk about some of the nuances of that vis-a-vis SB1 funding, additional funding. But each jurisdiction could run their own individual sales tax. However, some jurisdictions do not have a very good taxing power. Yet, everybody in all those jurisdictions shops at stores and others. So, in other words, they would contribute to that tax, so they should be the beneficiary. Yeah. So, I believe that we should go together.
Well, they also have the ability to tap into the Safe Roads and Streets Act. I know there's a match, and I know, at least in the case of the county, your CAO has said we can't afford the match, but that is an option in case cities wanted to explore it. They could go that route to, fix their own streets. My other suggestion all along has been have George Reed pay for more of the operations because they cause a hell of a lot of the damage. Thank you.
Thank you, Bill. Well, here comes a dynamic duo.
Easy now. Good morning, or actually almost afternoon. My name is Matt Toma with the Amador, president of the Amador County Chamber of Commerce, here with Brad Bernard, our executive director. Right. And we would just like to let the county supervisors know that we would be, the Chamber of Commerce, once we look at this, would probably be willing to help champion this cause. I'm probably the first person in this room that doesn't want a tax increase, doesn't want to give you gentlemen more money, but I know it's for a worthy cause. To have our roads in some of the shape that they're in, to bring, commerce into this county, we'd like to keep our roads in good shape, safe, obviously, for not just our locals, but for our tourists alike. So anything we can do, I believe we wrote you a letter, and we would also like that presented into the record. So
thank you, sir. Appreciate it.
Good morning, gentlemen.
Morning.
I would like to bring maybe some issues for you to consider, how we can maybe get some more money for roads. First of all, I'd like to ask, is our road director here?
He is not, but we have the engineer.
How many roads are privately paid for in Amador County?
I only know of our public roads. We have 410 public roads.
Miles.
410 miles of public roads.
So we don't know how many. I belong to a private road association, and this is why I'm bringing this up, is because we pay for our own roads there. Yet our gas tax money has been subsidizing the rest of the county for your roads. And I feel, okay, we're doing our fair share. We, yes, may use some of the public roads, most are state, for shopping and so forth. But I wonder how you might have from the TOT tax, the occupancy transit tax and tourism that brings more people and use of our roads into our county, why we can't take a portion of that tax to maintain the extra maintenance needed because of the extra people driving those roads coming to our county. Why can't a portion of that be used? The other issue I've heard brought before us is that we could get more grants if we had a self-help. I don't know why you can't say we have a self-help county by using as an example the private road system in our county that people are paying to help take care of the roads in our county, because businesses do use our private roads and we are paying for them. So I don't know how. I think it's good you come to a discussion before you all of a sudden decide I'm going to go for this tax or that tax.
Sherry, self-help, I think, is defined as when you pass a sales tax measure. It's not a private road.
But we're alleviating you guys from having to take care of our roads. So I would like to know how many miles of roads are in our county, and it's showing we are doing self-help. So are you going to come back to us and ask us to help you more again?
All I'm saying is, in order to get qualified as a self-help county, I think that's defined as
a dedicated sales.
A county or city passing a sales tax measure. That's what they view as a self-help county. I'm not saying you're wrong as far as the private subdivisions. It helps the county financially as far as roads. But once you leave that subdivision, everybody uses the same roads. But is it kind of a, I guess, could you say, is there, for lack of a better term, a raw deal for people that are in a private subdivision that does not have county maintained roads? I'd say yeah, but I know the county's not trying to take over any more private roads because we can't maintain the ones we have right now adequately. So why would we want to be taking more?
Okay, I know there was a time we were going to have a asphalt company come, and it would reduce cost if we had the asphalt company producing asphalt to pave our roads. The cost could be reduced to maintenance and getting supplies because
we've done all we can. I mean, we permitted asphalt plant now I own. I'd love to see them build it.
Okay, is it
not
being
much more
built?
we can do?
No.
Why?
We've invited, but they've declined. It's like getting a Winco up here. They don't have enough demand for the supply. We don't have enough people here to do that. So you'd have to have so much X amount of roads being replaced to produce it. The one thing I've talked to transportation down, we get our asphalt from Clements or West Sacramento. Even the small amount that we request, when we're doing patching, we're not assisting those plants. So they mainly carry about big batches. And so we're having to ask like 4 or 5 days in advance before that material, from our material that we need.
I understand that when they get here, the hot asphalt patch is cold. So I was just trying to think of, they may be little pieces, but little pieces and little costs add up.
Understand.
And the energy cost to drive the trucks down to get that and so forth is expensive. So
Not disagreeing. Believe me, I would love to have a plant here. Anything to assist us, it would be a great thing. And we're not blocking it from happening.
Okay. The other thing I'd like to hopefully have you consider is We are one of the second smallest counties in California. We have a tax base, 30,000 people here. Those people are having to fund not only our local government here and our local policies and services, but we have state and federal as well, plus special districts, and the list goes on and on. So just consider in your mind, it's not everybody can afford to keep going up, because right now certain governments are causing a great high inflation. And so all of us, including government, you, are receiving higher and higher costs to pay for.
Agreed.
So I just always have been, I want to look at every way possible and then come and ask for a tax increase. At this point, I'm not satisfied. I know the roads aren't being done. I don't know what the management problem is, if there is any there. I don't know if we're getting overcharged for services.
Actually, we're
And
doing
supplies.
the Shenandoah Road, and the estimate came in below our engineer's standards. So there was two companies that were very close at that, and we were very happy with it. So those companies are actually helping the county. So we're very.
Yeah. Well, I kind of object that it's everybody's responsibility when part of this county has a lot of people that are paying for their own roads.
Well, yeah, but Sherry, you drive on other roads that are county-maintained roads. You
Not
come
that
down-
many
you-
other roads.
Yeah, you come down, you probably come down Shake Ridge Road, you probably come down Ridge
And
Road.
my sales tax is going to you to cover that, driving on other roads.
Well, it's not enough, sorry.
Okay, I hear you. Everybody is saying that. Every government level is saying, we need more, and the private people are saying, we don't have it. If you're on a fixed
Well, this
income,
is
that's
what
it.
the vast majority of counties, or at least half the counties in the state, have something like this because they can't afford it
I
either.
don't like to hear what other counties, because everybody else is doing it, we have to do it. I think we need to take care of our county in the best way we can. So, thank you anyway.
One thing I would like to touch on, you talked about the TOT tax. Some of it goes to Chamber of Commerce, some goes to ACT, but also a fair chunk of it goes in the general fund, and and some that does go back to the roads. And what portion, it probably varies year to year, but some has gone towards roads from that.
I'd like to know
some
that amount.
Could some maybe be designated specifically to roads?
Yeah.
Yes.
That's a conversation worth having.
Okay, that's what I'd like to at least talk about. Thank you.
Thank you, sir.
Thank you. Yeah, I agree with that. I think we should dedicate a certain amount of the TOT.
Well, anything we always get extra on, we're always going to try to put it in the roads anyway.
Right.
As we're working on this.
Frank Costa.
Yes, sir.
I have a short request, and it won't cost you any money.
Okay.
Enforce the 10-ton weight limit on the county roads. We have roads that are just terrible shape, tore up, and 10-ton weight limits are not enforced. Huge trucks running all over the county. I live down in the Jackson Valley area. They're big, huge trucks go every direction down there, and none of them follow the weight limits of the roads that you can drive on that are permissible. But the 10-ton weight limit would save a lot of road, wouldn't cost you a dime to enforce it. Thank you.
Thank you, sir.
Thank you, Frank.
Anybody next?
I got
Yes, Bill.
Zoom, Jeff.
Bill, you want a pen?
Oh, yeah, let me.
Just one word in case you haven't heard. My next door neighbor on the other side of my barbed wire fence, George Reed's quarry, is proposing to the TAC on July 6th, go from what is now 6 a.m. to 6 p.m. to going to from 6 a.m. to 10 p.m. on during the week, and 7 to 3 on Saturdays. And they also want to maintain, Jeff, that right to the emergency responses. They want to keep that on top of everything else. I call my next door neighbor not a poor neighbor, a terrible neighbor, and that's going to be one heck of a fight if we move it through from TAC to the Planning Commission to the board. Be prepared.
Okay. Okay, anybody else from the audience? Okay, we got some Zoom people.
Thank you, Ms. Grambois. Please go ahead when ready.
Hi, my name is Cindy Grambois. I'm a resident of the county. First off, I would like to thank the board for having this conversation. Secondly, I would like to ask if there is any idea of how much it would cost the county to run a vote for the 0.5% sales increase.
Yeah, we looked into that in the past. If it's on a normal ballot, there shouldn't be any real cost, other than the time that county council would have to put into drafting the actual ballot language, but that would be pretty minimal.
I would
I
support.
think you pay for you pay for the
ballot.
printing cost too, I believe, portion of it.
Well, it's going to be on the ballot that goes out, so if it would be on the 2024 ballot, we're going to send those out, so.
It's not a nominal cost.
It's
I would
pretty
support
nominal.
it put on the ballot.
I went and asked elections the last time we discussed this, and they said no.
Okay, again, I would support it being put on the ballot. I think that people need to decide for themselves and play an active role in whether this is something they support or not. I do like and support the idea of investigating other possibilities of fundings like the TOT. I know that the fire assessment has been a hot subject. There's been a lot of misinformation. I do support it. I hope others will too. I think that there may be support for the 0.5-cent sales tax, so please consider it. Thank you.
Thank you. Okay. Next.
Thank you, Ms. Evatt. Please go ahead when ready.
Hi, this is Catherine Evatt, Volcano area resident. I'm glad you're looking at the 0.5-cent dedicated sales tax again. This is something the county started looking at maybe 15, 20 years ago and had a citizens committee convened through the ACTC. And then that was dropped for various reasons. But I think the structure of that committee was good in that it brought in community leaders from all sectors of the county to help promote the tax if a decision was made to go forward with it. Also, in terms of applying transient occupancy tax to roads, one thing that I think is a selling point for a sales tax is that everybody who buys goods in the county pays it. So if tourists come here and they buy wine or they pay for meals or they buy gasoline or whatever, they're going to pay that tax too. So they're really going to be paying their share of transportation sales tax that way rather than through the transient occupancy tax. I would also encourage the county to really look into getting an federal earmark. There's a lot of money in the infrastructure bill. And I took a look at Senator Padilla's earmark list for this year, and nearly every county in the Sierra Nevada foothills has an earmark for them for infrastructure projects and other community projects, but Amador County has not. So I know that our House representative doesn't do earmarks, but our senators do. So counties to the north and the south of us are taking advantage of the availability for federal funds. And you could potentially get a very large chunk of money that way and possibly not need as high a sales tax And I think it's worth exploring. I believe it's too late this year to put in an earmark request, but I would strongly suggest that you contact Senator Padilla's office, find out what the process is and pursue it so that we can get back, you know, federal funds that we pay to the feds now. Thank you.
Thank you. Brenda, if you could please state your name for the record. Go ahead when ready.
My name is Brenda Walker. I live in Pine Grove, California. And I have spoken to the Board of Supervisors, probably the last time was 2017, about my concerns for improving roads. I've listened to the discussion today and I've taken many notes because I thought everybody had a good point. These people in this county are not always happy to pay taxes. The reality is you will never be able to make everyone happy. However, you can take steps in the half-cent sales tax that will allow you to secure other funding sources. The roads in this county that we deserve as people take your bravery to address this problem. The reason I talk like that is because in 2017, I'm going to quote Mr. Onetto, quote, 2017, Ledger Dispatch, July 14th. Mr. Onetto said, the roads are showing severe issues and we don't have any money. The answer to the question is we don't have any money. Happens consistently from 2017, 2018, 2019, 2020, 2021, 2022, and now. Please quit saying the answer is no money. Please take action. Yes, I would be more than happy to serve on a committee or put up posters or whatever you need to promote this sales tax. The roads need your help. The road maintenance program was developed in 2015, 2016. It was a wonderful maintenance program. It even told you what roads to focus on, which is my other message. I live on a road that was accepted into the county in 1965 when the development was made. To date, there has been, aside from potholes, snow plowing, and a one-time ditch clean out, which left me with a 4-foot deep ditch that I had to fill, nothing else. So roads since 1965, I'm a number 9 on the road maintenance list. The county at 217, average county roads were 57. So I would encourage you, A, please go after the sales tax, and B, make it work for all county people, not just favorites. Thank you for having a nice listen for me.
Go ahead, Ms. Grambois.
Hi, Cindy Grambois. I wanted to add that there was some discussion on whether it should be for the entire county, the sales tax, or just county roads. I have kind of mixed feelings about it because of what occurred with Measure M and all the infighting and everything that occurred with that. I feel a little burned, so I'm kind of hesitant to go into a split situation again. But I also understand Supervisors Axe's point. I think that this is something that needs further discussion and thought. But I agree with the other comments that just put it on the ballot, let people decide, there's a perception that the board isn't taking any action. And I think this is an action that you can take and let the voters decide. And I'd also like to add, I've said this many times, there is a misconception that because property values or houses are a little cheaper here than in large cities and larger counties, that it's cheaper to live in a small rural area. It is not cheaper by any stretch of the imagination to live rurally. I'm sorry, that's an opinion, but I do feel that facts support that. Thank you for your time.
Yeah, just to add that, you know, we were moving forward to a ballot measure, but because the pandemic hit, we put it on hold. But some of the elements of that was that we would go together, that it would be population-based by jurisdiction, which is pretty straightforward. There would also be a 10-year sunset so that we would reevaluate the success of it and use metrics to measure that. So that's, and it would generate roughly for the county about $2 million annually. And we needed, you know, with SB 1, that's another $2 million. We do need probably close to $6 million annually, but, you know, it's not enough, but it's certainly better than what we have.
But the only thing is though, Frank, it would generate $4 million countywide. And you'd probably split it up, I imagine, roughly somewhere 50-50 between the cities and the counties, so.
It's like a 60-40.
Something like that, yeah.
Mm-hmm.
So I mean, so the county wouldn't get $4 million, we get probably maybe $2 million.
Well, that's what he said.
Yeah, about $2 million we'd receive, yeah. So Measure M was about $3 million annually. And now it's probably because sales taxes are, you know, have increased. It's probably more like, you know, 3.1 to 3.5. So we can get that data.
Okay.
We did have a sales tax measure for roads in the past, somewhere around probably about 17 years ago.
Measure L, right?
And it failed because we lost our champion. Our champion was the Amador Business Council that pretty much fell apart during the campaign. So it's nice to have the chamber representatives stand up and say they will be part of the championing effort. We also need Amador Council on Tourism and anybody else, any other groups in the county we can get to support it, because it's not an easy task to get that 2/3 or whatever the threshold is. I believe it's 55 or 2/3. I'm not sure.
I don't remember.
At that point, it was 2/3.
Yeah.
Just one last comment. I think one of the issues with Measure M, it's based on population plus call volume. And call volume is, you know, that can vary, but I think if you just make it population-based, it's pretty straightforward. You know, is it the best way? I think so, but, you know.
You know, I'd like to weigh in for us a minute. I think anybody that knows me knows I may be part of government, but I'm not a great big government type guy. It's not who I am. I've been here now a little over 16 years, and I don't like taxes. I don't like big government, I guess you might call it that. But one thing I realized along the way, I thought, you know, I looked at it and I tried pinching the budget here and there enough. I think some of the government county departments say they hate me, but I'm just trying to do my job. One thing I realized, with the competition you have for employees this day and age, and how everybody's bumping up their pay scales, other counties, cities, I realized, you know what, I don't see any way to beg, borrow, steal, wheedle, squeeze enough money out of our budget to get even close to being where roads need to be. And that was why a few years back, right, a little before COVID, Frank Axe and I, which I find kind of incongruous in a way. Frank's probably the most liberal member. Some board members might debate this. I think I'm the most conservative, but whatever. We got together and said, hey, you know, we can't fix the roads. We don't have the money. And we started working on putting a self-help sales tax together, and then the COVID came along and we dropped it. I'm kind of sorry. I wish we hadn't. It was, you know, it was no fault of Frank's or mine. You know, things are going south. It's not going to happen. I wish we kept going just to see where it went, but I guess the point I'm making is I realized at some point that there's not enough money to fix our roads in our budget, period. And that's why I supported a sales tax. If it comes to fruition, will it pass? I don't know. At that point there, we'll have done what we can do to address a need that I think we see. And is there grant money out there? Yeah, we've got some grant money. I've been talking to a gentleman who has contacted Senator Padilla, working on what Catherine says, trying to get a, budget earmark. But the thing is, our roads, there's not enough money for them. And SB1 helped. I think we're probably paying more for it than we should, but that has brought some money in. So I think you've seen a lot more work done on the roads in the last few years than you have in a long time. The money wasn't there before, period. And I mean, I don't care. People can holler, they can scream, they can say whatever they want. Fact is, look at the budgets, it's not there. So that's why Frank and I are looking at that sales tax measure again.
Actually, it was the whole board that authorized you two to work on it.
Oh, yeah, well, I'm sorry, you're right.
Just for clarity.
Board passed a resolution of intent.
I'm sorry, Mike, but you're right. The whole board sees it.
Hi, Sherry Curtis again. I would, since it's our county roads that need the money, I'm sorry, but I don't want to raise a tax that gives more money to the state at this point.
Well,
I'm not happy with how they're spending our money.
It wouldn't go to the state.
The sales tax gets split, didn't you say?
No, this one not. It gets split between the county and the cities. Locally.
It would stay locally. This would be, whatever came out of this measure would be a local money only.
I would try to also look at other ways to tax or assess or whatever, where it goes just to the county roads. The cities like to manage their own business. Let's let them do that, raise their money if they need it on their own. I'm not here to raise money for the cities. I would like to raise something to help our roads for the county.
Well, but that's how it's going, Sherry, because the cities have businesses that get sales tax. The county has businesses that get sales tax. I looked at the numbers and it's fairly even what the cities bring in sales tax versus what the county brings in sales tax. So we'd say we're having a sales tax across the county. It's split up, the cities get their chunk, the county gets their chunk. So what you're talking about is really what was being proposed.
Okay, but I haven't heard the cities crying for
they're asking.
money.
They're asking.
Oh, okay. But I would just, that's what happens. You get too involved, joined together with joint powers agreements and all sorts of things. You get caught up in having to take care of other entities that are not our responsibility. You guys are to fund our county, not the cities. So anyway, thanks.
Thank you. Any other, we got a couple more conversations.
Wes McDonald, I've been up here before. A couple questions. Measure M, does that have an end date?
No.
It goes forever? Okay. One thing I wanted to comment on, when I lived in San Jose, there was a big need to have more freeway, more lanes on the freeway. So we passed a tax increase to build that lane, and by golly, it got built. And we had signs on there saying, this is what we did with the money. And so I would like to suggest that if we pass this bill, that we put signs and let the people know, let's call it Measure N, I don't know what number it would be. Measure N did this. And so that people know that they're getting some actual benefit for what that we're paying. And the other thing I was wondering, I live off of New York Ranch Road, and we have a wonderful road on New York Ranch Road. I understand it was a private-public partnership or entirely paid by the Rancheria. I don't know which, was it entirely by them or was it partly?
So. Yeah.
Partly paid for that. This wonderful road, I am so happy about. Is there any way of getting a public or private-public cooperation on helping with the roads with other businesses in the county? Has that been looked at?
And we've tried to do a lot of that stuff, but the biggest thing is the two rancherias between the Buena Vista and the Jackson. The part of it is that they pay no taxes. So that was the benefit that they gave the county to put those roads in, because they know that their customers are using our roads. So that was kind of a payment back and forth, if that makes sense.
And Lois, on the New York Ranch Road, I believe that section was actually in the city of Jackson. So it was between the city of Jackson and Jackson Rancheria.
You're talking about the intersection? That was,
No, from
Up the road here, half mile.
China Graveyard on down. They paved that. I don't know about the sidewalks, though. I think that the Rancheria didn't pay for that.
Oh. Well, I want to put a pitch in for China Graveyard Road. Gosh, maybe we can urge the Rancheria to help with that, because a lot of their customers come across.
I had heard they were going to, and the city won some type of study, something or whatever it was, and the Rancheria says that, and they just, no.
Well, it's a big mess. I know they took away some trees on the bit deep curves. It looked like there was going to be some work done on straightening out some of the curves. I suppose that nothing's been done since, but anyway, if it's a place to put a list of roads we want fixed, I want China Graveyard on there. Thank you.
Thank you.
Good morning.
Yep.
Good morning. Keith Sweet, formerly Jackson City Council member. This is my first public meeting since I left the City Council 2 years ago. I'm not even sure why I'm here. It's so nice not having to sit through these meetings. But the comments relative to New York Ranch Road, the City of Jackson paid for that, and we were reimbursed for it under an agreement with the Rancheria. There are other particulars, but that's essentially what took place there. As far as the self-help tax, or as far as the half-cent sales tax, I was the treasurer for the last attempt for the county to do that. Put in a few dollars of my own, along with many other people, in order to for us to carry the private presentation, since the county can't participate in that, or since ACTC can't as well. We haven't had a really good presentation today as to why we need to have the tax. I mean, it's hard for people to hear just a figure here, 6,000 here, 6 million here, whatever. But very clearly, neither the cities nor the county on an annual basis generates enough money to maintain our roads. We've known that for years. Every year we go deeper and deeper into the hole. And when we're talking about fixing our roads, if we're talking city and county together, and I don't have the numbers in front of me because I've long since tossed that information, but I know that we've put together, within the last several years, ACTC put together a really nice presentation with all the figures and what it takes. But we're looking probably at $13 million a year, at least, in the hole every year.
But you're talking countywide.
I'm talking countywide.
Right.
And obviously the law requires, if you're going to be in a self-help county, in order to get those state monies, the tax has to be it's a sales tax, and it's spread up amongst the counties and the cities. So I don't think there's a question that neither the county nor the cities generate enough money on an annual basis to fix the roads. So we just keep getting worse and worse. And I know people don't like to raise the money, but the last time we had it, we were competing with the fire department. Last time we ran a half-cent tax. So we had two assessments going at the same time, and they had more beef behind them than our committee did, as a remembrance in terms of what happened there. So people were voting two taxes at the same time. Hopefully we do not get into that same situation this time.
people don't like taxes, period. And to get a half-cent sales tax, we can justify without question. The information is there from both the cities and the county as to why we do not generate enough money on an annual basis. It's clear to anybody who takes the time to look at it and read the information, the statistics.
Yeah, we put together like a white paper that went through what the costs were based on the work that ACTC had done initially, what the annual costs were, what we were getting from SB1, and then what the deficit was.
Right, and the last white paper that came out was very, very nicely done. I think Robin Peters did a really good job on that. And we need to resurrect that and the other slides and PowerPoints and everything else that went with it, because it's, anyway, I'd be more than happy to work on the committee.
Great.
Thank you, sir.
To push forward on that.
Appreciate it, Keith.
Yeah, by the way, Keith, I played pickleball last week for the first time.
Well, good. Yeah, I've got my pickleball uniform. I played this morning for 2 hours, so. Anyway,
Good for you.
Okay.
We want to see all of you down at Gator Park playing pickleball.
Go ahead, Ms. Evatt, when you're ready.
Hi, thank you. This is Catherine Evatt again from Volcano. I just wanted to make a couple of points. One is that if you have a special sales tax like this, it's better in Amador County to have it apply countywide, including the cities, so that people know what the tax rate is in every city and it's the same as the county. I mean, that would be a real kindness to people who do business in more than one town in the county, or do have business locations in more than one spot. It's just a practical matter. As far as allocating the funds among the 6 jurisdictions, the 5 cities in the county, it's fairly simple to do it either based on the taxable sales data from the State Board of Equalization, which I used to have a lot to do with, or to base it on some calculation of road miles and do it so it's kind of a fixed, road miles would be a fairly fixed amount. Taxable sales would fluctuate, but the data is readily available. It tends to be 4 to 6 months out of date, but there are ways to figure out allocations based on, objective numeric projections. Thank you.
Yeah, we did look at road miles. It really, really, really favors the county, and the cities would balk at that. Also, we're trying to encourage smart growth, which occurs in the cities where it's more dense. And this is actually contrary to that. That's rewarding sprawl to a certain extent. I think population is what it is. And that's the tax base. Those are the people paying the sales tax. We can't really count the people that come from out of the county that pay it, but I would advise against that. And then you get into one of these really complicated apportionment schemes that you have to put that into a ballot measure, and the voter's not going to understand it.
Hey, anybody else from the public? Motion to close this public hearing?
So moved.
Okay. All in favor?
Aye.
Aye. Opposed? 5-0. Back to the board discussion. It had been brought up to the board previously to have me sign a letter to start the process with the cities. Is that something we want to do?
Well, I'm in favor of that. I'll make that motion.
Okay.
Or do you need a motion or just direction?
What do we need, Chuck?
Direction should be fine.
Direction fine? Okay.
I think I gave you a draft letter, but you can rewrite it if you want.
Yeah, I know. So we can go on that one. So that will close out 5A. On to 5B.
Mr. Chairman, real quick, an announcement. Anybody who's here for the 11 o'clock IHS public hearing.
Oh, that's right.
We're going to cancel that meeting.
Okay.
And reschedule it for either 2 weeks.
Wonderful.
Yeah. So
Good idea.
in the interest of saving some time.
Yes. Okay. On to 5B, Planning Department, consideration of Planning Commission's recommendation to approve a request of variance B 23-1 Sergeant from the front back 25-yard setback. That's the one that I was talking about. Okay. That was the one that they sent an email.
Yeah, so this is Krista Russell from the Planning Department. I can go over that. Yeah, so this is property at 33829 Fremont Road. It is in Kirkwood and zoned R1 under the PD, Plan Development District. It's almost a half acre, and so this is requesting a variance from the standard 25-foot front setback to allow the construction of a detached garage. That's fairly standard up there. A lot of people have wanted to do that. So I did want to note, so this did go to TriTag. They had concerns over the snow storage area, but then that was addressed by the applicant when it went to the Planning Commission. And so Planning Commission did recommend approval along with the exemption. I did speak to Gary Sargent, who's the applicant. I spoke with him yesterday, and we'd been talking about how he had concerns of the, I guess, term that the variance is active for, just because it has gone through this whole process and most of the year for building has gone by. So he did request that the active term be from this June to next June. So it would be from, well, no, not this June. It would be next June to the next year. So it would be through 24 up to 25.
Right.
And that would allow him time to have someone found to do the work, that kind of thing. And I did want to note, so in the code, generally, unless it's specified, the variance would expire a year from the date that it's approved. But this would allow you guys to specify a change in date for it to be effective.
So what we're looking for is to extend, allow the variance plus the variance to the date also.
Yeah, I mean, it's up to the board's discretion whether they want to make it active from the date of approval onwards.
Because I know
more than a year, or
I just visited over the weekend, and they still have plenty of snow up at Kirkwood.
Yeah.
So there is serious amount of snow still sitting up there that you have to prevent building. Okay. Do we have anybody else that wants to talk on this item? Okay. Back to the board. Motion to close the public hearing.
Move.
Okay, I didn't hear that one.
Move.
Okay. And who's the second?
I'll second.
Okay. All in favor?
Aye.
Aye. Opposed?
I'm gonna have to say it louder next time, I guess.
I think so, because everybody sounded at one time on that one. You guys are all on the ball. Okay, back to the board for discussion as far as this variance and possible allowing them an extra year.
It looks like there's some talk about impeding snow removal, but it looks like they talked to maybe Kirkwood Meadows PUD, and they came to a resolution on that.
Yeah, I believe they have been talking to CAMPUD from the beginning, and it also had approval from the Meadows Association. And I think it was just that TriTech didn't find that they clarified where it was enough, so they did resubmit the plans that clarified. So it didn't go back to TriTech after that. It did go to the Planning Commission, but Planning Commission thought it was adequately addressed.
Yeah, it sounds like that's a problem that has come up is, a lot of times you make decisions in government or in private business, and down the road something happens, you go, oh, we didn't quite think about that. And it sounds like the Snowmageddon has really brought it forth.
Yes, it has.
So what are you recommending as far as the variance? Is it a year and a half, 2 years?
So the way the request was from Gary, he said the 1st of June 24 for it to start. So then it would expire a year from that date.
But we,
that was what he requested.
We need to have it continue, excuse me, but we need, since it's a variance starting right now, to the end, we need to have it continuous, or does it fail, or?
You can approve it to be active from June 1st, 2024.
Okay.
If you don't specify, it's from the date of approval a year on. But if you specify, it's really up to the discretion.
Okay.
Why can't we approve it to be active from today, so if they have opportunity, they can get started?
That's my thoughts.
In the end.
Yeah. No, that's what I'm saying. That's kind of what I put out there for the 2 years myself.
Yeah, I don't have a problem with that.
Yeah.
Makes sense.
Well, do I have a motion on that?
I'd move the resolution approving the variance, but make it active through, for a 2-year period from today. It would make it active into June of 2025.
Okay.
And, also approve the findings and the adequacy of the proposed notice of exemption.
I've got a question on that. Just thinking, we're in June right now, and there's a lot of snow up there.
Yeah.
So should we make it a little longer, maybe?
Like the
Well,
October.
we're making it,
2 years.
Yeah, two construction seasons, I would give them,
Okay.
I don't care, we can make it to the end of 2025 if you want to just.
They really do experience winter there, so.
That would make it essentially 2.5 years about.
Yeah, I think if they can't get it done by then, they're in
I'll modify the motion so that, it allows them to variance through December 31st, 2025.
I'll second that.
Okay. Actually, 2.5 feet.
Yeah.
Okay. Okay, call for the vote. All in favor?
Aye.
Opposed? Be 5-0. 5C, consideration of Planning Commission's recommendation to approve a request of zoning change from R1A, Single Family Resident Agricultural District to PD Plan Development in conjunction with a use permit for an event venue.
So this project has been before the board before. It's Hoover's Hideout, and the applicant was advised to pursue a zone change and plan development use permit, basically, for their existing, commercial event venue that's up at 43300 Highway 88 in Kirkwood. So the current general plan designation is OR, which is open recreation, which is consistent with both the existing residential use as well as the proposed uses for the event venue. Let's see, so this project has gone under fairly in-depth environmental review, so the conditions are very, specific to the proposed project, and the project was reviewed throughout 2020 and through 2022, and went before the Planning Commission in May of this year. And they did approve the mitigated negative declaration as the environmental document, as well as the use permit and recommended conditions of approval that go with the project. And then they did recommend approval of the zone change to the board. So the zone change and the plan development district and the use permit are all kind of intertwined. So their approval of the use permit is contingent on the approval of the zone change.
Questions?
Yeah, I've got one. Well, more than one. I saw in here somewhere, under the conditions of approval, it was on number 25, on-site pond stocking prohibited. Applicant shall not transport any fish within Tragedy Creek to or from the pond. I guess the question I'd have is, can the fish naturally migrate, or is this prohibited too?
I believe it's for the artificial transplanting.
Something, the conditions are pretty insane.
Well, and that condition was recommended by the
Fish and Wildlife. Yeah, I'm just looking at, I don't see how anybody does anything up there. No offense to planning departments, you operate in those rules, I guess, but it's insane.
Anything else?
Not just.
Nope. Anything over here? Okay. Anybody else from the audience?
Glad we weren't talking about our roads earlier there. My name is Chris Saylor. I represent the U.S. Forest Service based out of the Amador Ranger District, El Dorado National Forest. I've been asked to come here just to share a quick concern about maybe some commercial operation happening outside of the boundary of the private parcel there, and just encourage the landowners to work with us. If they do desire to go outside that, we can get them set up with a permit for proper use of that.
Okay.
Thank you.
Thank you.
Running out of space.
It's been one of those days.
Okay.
Got lots of paper.
Well, good morning.
Morning.
Well, no, it's good afternoon now.
Yep.
Sorry about that. Mr. Chairman and board members, my name is John Munn. I own property adjacent to Highway 88 that includes an easement used by access by the hideout. Not going to list again what has gone on with the hideout. This should already be included in the comments, letters, messages from me and others that are part of your hearing record. And this has gone on for years, so that is a long record. Instead, I want to comment on where to go from here. I'll start by saying again that it has not been my intention that the hideout go out of business. I think that most of us here would agree with this. But my meetings about the hideout indicate that my concerns are also valid. Next, I'd like to start by describing the hideout roadway from Highway 88 to where it leaves my property so that later comments can be better understood. Between Highway 88 and my property, the boundary is the right-of-way owned by the state of California. So I do not own the hideout entry from Highway 88. This right-of-way has been designated by the state as controlled access and is administered by Caltrans. From my property boundary with the right-of-way, the roadway easement goes east about 1/8 of a mile to a clearing. Most of this is on a parcel adjacent to Highway 88 that is zoned R1A. Near the clearing is an intersection of streams that start on the other side of Highway 88 in the Crell Flat and Podesta Meadows. At the clearing, the roadway turns toward the southeast and follows along the southwest side of Crell Flat Creek for about 1/3 of a mile. This parcel is zoned TPZ. The roadway then turns toward the east, crosses Crell Flat Creek, and climbs to a small flat about 1/6 of a mile, where it leaves my TPZ parcel and enters another owner's property. The total roadway distance on my ownership is a little less than 2/3 of a mile. My main concerns are about the future problems from lack of compliance with state and county laws, regulations, and standards for the entry from Highway 88 and the roadway changes on my property. I want access to and on my property to be legal for all of my uses. And I don't want to be paying for changes or maintenance needed for use by the hideout. I'm also concerned about future claims of prescriptive rights. I'm not certain about all the past activities on my property, but Mr. Hoover did claim a prescriptive easement to reach another parcel. This has caused me to think about earlier uses and users. Based on my contacts with Caltrans, crossing a state-owned controlled access right-of-way requires a process called decertification, which contradicts the Caltrans comment about the hideout. I don't know what the agency's going to do about that. This has not been done at the hideout's entry. I mean, decertification hasn't been done. And there is not a permit on file for access to Highway 88, so I presume that the current entry to the hideout is neither approved nor legal. If it goes through decertification, I will need access. This decertification is a time-consuming process, and if it's required, then it's likely that the hideout's conditional use permit cannot be active this year. That's just a time thing, and you'd have to talk to Caltrans about that. At the clearing, the hideout easement is next to the Podesta Meadow stream. After the Podesta and Crell Flat Meadow streams intersect, slightly downstream from there, the easement is close to and eventually crosses Crell Flat Creek. If roadway improvements are needed for commercial use, the proximity of these streams might require moving parts of the easement to meet current watercourse regulations. And that's the reason I've been pretty adamant about no changes to that part of the roadway. I just don't want the regulatory agencies down there looking at it. And any crossing structures would also need to be reviewed. Such improvements would certainly require county grading permits and inspection by state water quality and fisheries agencies. Now, as a compromise, I'd agree to accept the nuisance of traffic amounts needed by the hideout that are specified in the current, as I understand it, approved use permit if the following 4 conditions are met. First, both the roadway on my property and the hideout entry must have needed agency approvals and meet all legal requirements. I would have use without recompense of all roadway improvements on my property and of the entry to the hideout for any legal purposes. In other words, I need to get on. Future modifications within the easement on my property beyond what is required by the county for private lanes would need my consent. And I chose private lanes simply as the most likely roadway type that might be used down there. And I need to obtain a quiet title from Hoovers for any claims of prescriptive rights on my property. So those are the terms that I would need to accept the traffic. And these terms would need to continue for future owners of my property and of the hideout. The currently adopted conditional use permit appears to cover my concerns about a legal hideout entry and a legal roadway. So if my other terms are accepted, I'd no longer oppose the project. There would be no purpose to it. My traffic concessions are based on the currently approved use permit and would keep the hideout in business. I think that's been a big concern, is keeping the hideout in business. I'm proposing that this would accomplish that if it can survive the county's already adopted conditions, which that's between Mr. Hoover and the county. While my other terms provide some assurance about use of my property in the future and do not increase costs to the hideout or to the Hoovers that I'm aware of. Continuing this hearing to a future date would provide time to see if conditions can be added to the use permit or if an agreement can be reached. The board could also use this time to straighten out requirements in the Planning Commission's adopted use permit. Before a vote, I think that there are at least a couple issues that the board needs to deal with, and I'll just use a title here so to save some time. First, what specific deviations to the board-approved county code will be needed to activate the conditional use permit? And second, the board should also specify a roadway type for this project. There are roadway standards included in some of the use permit conditions, but no mention of whether a county road, street, private lane, driveway, or something else is being required. The Caltrans Highway Design Manual that's cited in use permit condition 45 describes easement requirements, but provides very little detail about roadways. And knowing the roadway type is very important to property owners who are not part of the conditional use permit, because we need to know what future uses the roadway would allow. Uses are connected to roadway type in the county ordinances. So after so many years of non-conforming use by the hideout, access problems still have not been fixed, and R-way standards are still being used for commercial activities. Now you're suddenly supposed to approve zoning that allows commercial use without knowing what code deviations are needed or if commercial uses will even be possible. I don't understand what the rush is all of a sudden that prevents you and the public from reviewing all of this zoning change proposal. Now, if you approve this zoning change for the hideout without addressing my concerns, and after all that I've been put through, I'll be disappointed. But I'm not going to go away. And it would be clear that it's no longer in my interest for the hideout to stay in business if this zoning change is approved without taking care of the other issues. So my suggestion is that you continue this hearing into July or August to provide time for your review and to reach an agreement. In the meantime, as I previously suggested, your current allowances for hideout operations should be continued for this year. Hopefully, the results from a decision this year will be in place next year. Now, finally, I have some comments about procedures that I just learned about yesterday evening. I mean, this thing's been going on for years and years, and then all of a sudden, yesterday evening, this pops up. First, I want to talk about conditions in the use permit. Your introduction to this agenda item indicates that the board can choose to modify the use permit, whereas I thought that conditions in the use permit were fixed when approved by the Planning Commission, subject to an appeal to the Board of Supervisors within 10 days. That didn't happen. Or some later condition-specific amendments by the board. I mean, it's the county's code, so the Board of Supervisors, they can decide what applies, what doesn't apply, what the language should be. If conditions are subject to wholesale changes, and those are conditions in the use permit, what is the point of and why would anyone bother with review by the Planning Commission? So I did not come prepared to suggest changes to condition requirements. I didn't realize that, that was going to be part of the discussion today. Second are deviations to the code language in Fire and Life Safety Chapter 1530, which includes a process for deviations to this part of the code. So 1530.070 states that requests for a deviation shall be made in writing to the inspection authority by the applicant or the applicant's authorized representative. Well, this hasn't happened. How these deviations are to be developed is contained in Section B, where there is no mention of non-specific agency-required deviations like we see found in the conditions for the use permit. Instead, deviations are supposed to be proposed and described in detail by the applicant, and then are supposed to be limited to minor changes in the code, which is actually in the eye of the beholder. So I don't think that has a whole lot of limitation to it. But the board should have specific requirements and language of deviations to consider before approving them. In other words, you're going to be voting, when you vote on this zoning change, to accept deviations that you know nothing about. That language is not included in the conditional use permit. So I would suggest that you continue this hearing, give yourself time to review those deviations, and some time, perhaps, to be able to put together an agreement that would just cause me to go away. So thank you very much, and I'm sorry that this took so long. But after 7 years, a lot of things have gone on. Thank you.
Sure. Hey, anybody else from the public? Anybody on Zoom?
Not at this time. Yes,
So it's-
Mr. Chairman, we do have a comment now via Zoom.
Okay.
Ms. Evatt, please go ahead when ready.
Hi, this is Catherine Evatt. I live near Volcano, but I also have a cabin in the Corral Flat area. So my comments are based on my knowledge of the area, my knowledge of emergency services, in that area, and a longtime interest in county land use planning. I think, everybody can agree that the Hideout is a beautiful facility, but it's a beautiful facility in the wrong place, and it's in a place that is inherently unsafe for regular gatherings of 200 people or more. Land use planning is about making sure development happens in the right place where there is adequate infrastructure, there are sufficient emergency services in order to protect health and safety of people as well as the environment. And the Hideout is 2 miles from a state highway, more than 50 minutes from a structure fire engine, and that's based on my analysis of a fire that occurred off Corral Flat Road in 2020, and at least 30 to 40 minutes from an ambulance. So you're potentially having 200 people down there on a regular basis, that far from professional emergency services, if those services are even available. I think the county staff have worked hard to put in conditions to do what I would call rounding the edges of the square peg that the Hideout is. I mean, the Hideout is a square peg that doesn't fit in the round hole of a remote rural mountain site. And I would also ask you to consider the precedent you would be setting if you approve this use permit. If you can build a commercial facility in a residential zone and operate it for years, making a lot of money while you are working illegally, and then get the county to change your plan to make your facility legal, why would anyone bother to comply with the zoning and codes at all? I mean, this is just an example of, trying to make something legal that should have been cracked down on long ago. And I don't think it's a responsible thing for the county to do. Thank you.
Hey, any questions from the board?
Yes, with regard to the road deviations, what are they?
No, it is not.
I can touch on it. So there was an application for deviation, and that was submitted as part of the application packet. So, I think it includes a letter from fire or a response to fire's comments from the Hideout, and it addresses the specifics of what the deviation would be.
Which is?
Wasn't that in the conditions also?
Yeah, it was translated into the conditions as well, but here, I can
I don't
pull
think
it up.
it's in the conditions, that was the point.
It is, but not in the form of the deviation. So in the application,
They just used the term deviation.
I don't have the page, but it's part of the application packet, and it has the form from building, and it does. So the attachment to the deviation are the recommendations to help with fire protection, including water pressure system, hydrants, faucets, extinguishers, contact with the fire response crews, and then the roadway averages, and turnouts.
Were those deviations accepted by local fire as well as state?
So it's been reviewed, but it hasn't been approved yet because they're waiting to officially submit the deviation application until they have a permit.
Your mic's not on.
It should be
Turn on your mic, Richard.
basically the same thing. And then,
Basically, it sounds like the same thing under condition 49.
correct.
One thing I thought was kind of interesting, and they're talking about 220 people at an event versus 250, and a trigger for having a staffed engine present. I mean, I don't know how many people are at Bear River Resort on a weekend, but I mean, you're probably talking 300, 400, you're on the lake, 300, 400, 500 people. And so,
But it's a paved road.
not all of them are.
A lot of it is.
Yeah, I mean, it's,
Side of Bear River, is it?
you know, look at that,
It's
and
actually a 2-lane road too.
I don't mind public safety, but it's kind of like, have a staffed engine, and maybe it won't be triggered all the time, so I can maybe live with that, but that's a pretty huge expense. I'm thinking about, what about all the people, other places that they may be, and there's no staffed engine required. It seems a little bit like overkill.
Mr. Chairman, we also had another comment when we went to circle around from someone who couldn't get their hand raised up there.
Okay.
So, technical issue.
Yes, sir.
Mr. Chairman, members of the board, Bruce Baracco, 44 Eureka Street, Sutter Creek, and representing the applicant. I think I can provide some clarification on the deviation issue. Under County Code regarding dead-end roads, 15.30.120A. It applies in this case to parcels zoned 20 acres or larger. It requires that turnarounds shall be provided at the terminus of the road, and that turnouts be provided at a maximum interval of 1/4 mile. So the conditions of approval in the use permit exceed those basic requirements, and that's also then tied to the deviation, which has been pointed out. The application has been filed with the building department and is awaiting finalization of the project approval. So, any questions, be glad to answer.
I have a question before you leave the mic. On Mr. Munn's request to approve the 4 items, can you speak on behalf of the applicant regarding those?
Yeah, I don't think those apply to this agenda item, which is rezoning.
Okay, I'm just trying to save the applicant getting sued, so maybe Mr. Hoover can speak on it. But. You have Tom Sweat on there too.
Let me go ahead, you want to hear from our attorney?
It's up to you.
Richard, could I maybe go first? Because, so his requests were in the letter that was submitted to the board as well. I'm just not sure that most of them are something the county could include as a condition of the use permit. The only one really is number 1 about the encroachment onto Highway 88, which I think there's already a condition that addresses. They need the legal encroachment onto Highway 88. The other 3 are really more private issues between the owner of the property and the party that has an easement.
I realize that. So,
yeah, so
is he restricted from speaking about it then?
But no, I think, but I don't think the county can include it as a condition in the, whatever you do here today.
Agreed.
But it doesn't mean they can't agree.
You know, actually, being as you're up, Greg, and maybe it's a planning department question too. Something I found kind of, I do feel Mr. Munn's pain to a certain degree. He's asking why can't he have similar type uses on his adjoining property? And now that's probably you're getting into maybe a general plan, zoning, yada, 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 but I mean, it seemed like a fair question to me. Maybe in the future, maybe something we might want to consider looking at.
That's something for him to apply for, just as the Hoovers are applying for it, gone through all the situations, isn't it?
Yeah, it's a zoning issue also.
Right, it's a zoning issue, but you gotta apply to have your change.
Yeah.
We're always kind of playing in between as the mediator on these things, and I mean, we've been asked today to hold off on this until some of these other issues can be resolved. So I think the board has to look at that too. Do we want to, roll this over and extend it?
That's up to the board. I just didn't want the board to think that you could impose those requests into the use permit.
But I'd like to hear from Mr. Hoover's lawyer if they're even receptive to that.
Tom Hoover, representing the Hideout. You know, this has been a fairly long process, and you've been involved in it from day one, even to the point of pointing us in this direction. I'd have to agree with Mr. Oneto's comments. We are conditioned to death. You barely can move up there without having some condition that you've got to look up and call some state agency to check with. We're trying to comply. Mr. Munn's comments have a lot to do with his interpretation of things. We did apply for an entry permit off the highway. We did receive that with instructions from Caltrans what we had to do to comply with that and final it. Mr. Munn's comment is that Caltrans did it wrong. Now Caltrans is saying they would like to see a little larger entrance, and they would then issue a commercial permit, which basically takes away from is your current access legal or not? It's one of the conditions in the use permit for us to change our entrance to comply with a commercial entrance. So we plan on doing that. The other issues have to do with Mr. Munn's legal right to use that right of way. It's non-exclusive. He uses it presently. We've never opposed that. I don't know what his future uses are, so I can't address that he wants to use it for some future use. I don't know what those would be. And it's always been there. We're the only ones that maintain it. There is no contributing from the Munn family or anyone else.
So condition 2 from Mr. Munn, you don't seem to have an issue with that?
Can you recall
I can read it to you. The hideout entry and roadway improvements on my property, so the part that he owns, must be available for my use and for the use of future owners for any legal purpose.
I think that's what it is presently.
Okay.
As far as the easement, when I bought the property, the easement came with it, came with the property. It's conditioned. It has a width determined. It has a map that's recorded here in the county showing it. I think the conditions were 50 feet wide. They were for road and utility purposes. And those were the conditions. Mr. Munn seems to feel that I need his permission to work within those conditions. So if I expand it from 15 feet wide to 20 feet wide, like the county has suggested, and that we have been complying with because we knew it was probably coming, and you can't do that all in one summer, so we've been working on it for years. He's always objected to that. Now he's added that we should, if the county requires it, it's okay, he'll agree with that. But should we need something else, say we want to put in a power line, say we want to add an extra turnout because it just seems like that's something that's necessary for our traffic flow, we have to go to him for permission. Frankly, I don't think we'd ever receive permission on anything that we request from him, just my personal opinion. As far as, I have an easement that's been granted to me with the property. We now have requests to condition that easement. And I don't really feel like it's necessary, and I don't even know what's hiding behind those requests, that I have to limit what I already have. We're not bothering anybody. We have a 50-foot easement, we're using maybe 20 feet of it. We may need another 5 for some drainage ditches. Still, we're less than half of the easement. We don't enjoy putting money into the road. Believe me, that is the last thing we'd like to do. But we also would like to make it safe for our customers. And right now, it's probably 90% 2 lanes. And, you know, to address the fact that we're in the wrong location, you'd have to say Caples, Silver Lake, Bear River, you know, everything is in the wrong location. It's in the
Mount Everest.
Everything is not in the city where the population is. It's what makes Amador County what it is the upcountry. I don't think people rave about our cities as much as they might say about the upcountry. The fact that the hideout is in the location is because of the beauty of it. And that's what brings people in. If we were down here in the Ione in a flat field, I doubt we'd be as popular. So I think the fact that the upcountry is the upcountry because of the beauty of it, and our facilities that people use are there because of that beauty and the demand. Personally, I think the hideout is in the perfect place. Not going to bother anybody if somebody makes noise. Somebody wants to fire a gun off, not going to bother anybody as long as they don't hit anybody with it. So, you know, I think we have to look at Amador County and say what's unique. And I'd have to say the hideout is one of those unique things of the upcountry. It brings in a lot of people, brings in a lot of revenue to this county. We employ a lot of local people to help us or help the people putting on the event. I think it's a good thing. And as Mr. Oneto has said in the past, if you want to look at revenue enhancement off of tourism, the hideout is one of those. We don't ask a lot from the county. Just as soon you leave us alone and we exist without your help. But we started this in 2016, 2017 by going to the Planning Commission to get a use permit. And it's been a long road. It's been an expensive road. We've had to do a lot of interesting studies that amounted to very little, but were costly. We're there now. We have completed all the tasks that have been requested. We have been conditioned to death. Mr. Munn's concerns that certain things haven't been addressed, I'd have to argue with that they have been addressed. We've been working with the fire department probably for the last two years or better. They've been on site more times than I can describe. Nothing upcountry is easy. If there's a problem at Bear River or Silver Lake, there's a response time. It goes, if somebody falls and hurts themselves in the backcountry hiking, there's a response time that comes with the area. Not everything can be right next to a fire station. We are probably the safest spot. If there's a fire, we have a lake. We have granite mostly around us. Most of our firefighters, and we get a lot that get married there, indicate that's about as a safe zone as you can get. My worry would be Mr. Munn's property, which isn't maintained very well and is loaded with dead trees. That and Highway 88. If there's a fire that stops Highway 88, it doesn't matter what. We're not going to send people out and try to get them through a fire zone. We depend on the U.S. Forest Service. Primary, they are our first responder, and they govern us more than the county does, and when it comes to fire, because they're up there. They're the ones that are around us. They come in and check on us. They bring their engines in. They use our road as something to help young drivers learn. You know, we're about as safe as you can get in the upcountry. There is no guarantee in the upcountry. It doesn't fit all the boxes. But I think from what we've built and what we're trying to provide, I think we're reasonable. The road will be, it'll be 2 lane, but it still doesn't help you if the forest is on fire.
Well, there was I guess an example that Mr. Munn pointed out, that he built a stream crossing, you didn't consult him on it, it wasn't legal, and eventually you had to take that down because Fish and Game, said he didn't have a permit. And he was also concerned that this would impact his ability to log his land.
Yeah, Mr. Munn was wrong on almost every point.
Well,
I
you
did consult, I
did
did
take it
first.
down, right?
I did take it down. I did consult Fish and Game to begin with.
Okay.
They gave me direction in writing. Mr. Munn complained enough to every state agency he could find. He brought somebody up. They decided I needed more of a permit. So I went in and I applied for additional, new permit to finish it. But then if any of you work with Fish and Game, you know it's not an easy task. And after years of completing all the items they asked me to complete, they still would not finalize a permit. Structurally, it was designed to handle anything and everything Mr. Munn ever has designs for upcountry. Extremely, and I had the structural report for that.
It was primarily constructed from wood or logs?
No, it's concrete and rebar, built very low to the ground, because upcountry, we have a lot of fallen trees in the stream bed, and if you build anything high, you would create a dam when it starts to flow. You need something that'll flow over the top with heavy, which was basically the Forest Service code book. We got in the middle of an argument between outside Fish and Game and inside Fish and Game. And at some point, a consultant said, we can finalize your permit, but it's gonna cost you $50,000 for us to do that. I said, I can build a lot of bridges for $50,000. It'll cost me $2,000 to $3,000 to pull it out. So now we're driving through a creek constantly.
Wonderful.
Yeah, just the thing you would think that Fish and Game would want you not to do. But that's the direction we have. So at this point, I think we have finished everything that's been asked of us. Mr. Munn's concerns about prescriptive, I don't know. I'm not sure why I'm signing away. I don't know that we're using any of his property that isn't already deeded easement. That would have to be something between us that we'd have to look at. I don't know what he's referring to when it comes to what part of his property that he feels we're still using prescriptive on. There's some very old roads on his property that were used to begin with that have not been maintained or used anymore.
I have a question. Talks about directional signage, and it's a little ways back into the hideout, and it looks to me like we are limiting signage. If planning department's listening, it's talking about signage, Krista. It appears we're limiting directional signage. And in the mountains, sometimes it's kind of nice to have a little bit of directional signage, maybe. I was wondering if that's something maybe we could look at making it'd be like page 370, and the conditions. It's right under mitigation and monitoring reporting program. I think it's condition number 4, item 17.
Okay, yeah, I see it. So, let's see. So this was, basically proposed by the applicant. We did offer 2 kind of draft options, one which would require them to have specific signing kind of, limited and conditioned. They just opted to, I think, have it just be the standard. It has to be signage consistent with the code, so.
Yeah, so I guess maybe I was asking maybe if Mr. Hoover, I guess you could probably put signs up and nobody care, but it might be something, you might need a little bit of signage saying, hey, that way. That's all I was thinking. Also, I mean, as I got you up, Krista, item number 7 in that same, number 4, item 7, condition number 4, item 7 talks about waste disposal, and it specifically mentions ACEs. Shouldn't be ACEs or any successor or franchisee or whatever for the future.
I mean, that can be changed to that makes sense
Yeah.
to me. Yeah, and that was the language that was proposed by the applicant as their current service, so.
Yeah, I'm
Right.
just saying,
That's why it was written
if
that
Bates
way.
ever sells out and becomes, you know, Billy's garbage service.
Right, and I did want to, respond to outdoor advertising, so I don't have the sign code in front of me, but, I mean, PD is kind of interesting because the sign code limits depending on the nature of whether it's a commercial or recreational. So they would be, for their commercial uses relative to that, it would be limited to commercial uses under the sign code, I would assume.
Okay.
So, Krista, while you're here, number 18, commercial light and glare, it refers to, county regulations. Do we have county regulations on light and glare?
So this refers to the general plan mitigation measures. So from the 2016 general plan, there are standard, mitigations that are provided that should be applied, that all new development needs to be compliant with. So it's not a specific ordinance, it's just, those are the specifics as provided in the general plan EAR as mitigations.
And then, with respect to, I don't know, I guess in item 35, but I saw it in other places, emergency response plan, communication, they'll have satellite phones, and is there some kind of radio, and is there a redundant backup?
That would probably be a better question for the applicant and/or Amador Fire Protection, District, because those were discussed between AFPD and the applicant, and this is kind of what they ended up agreeing to, so I don't know if Tom wants to speak on that, because I believe they do have kind of multiple options.
Yeah,
that
that
they
would
currently
be
employ.
something that would be really important.
So as these conditions were developed, our technology has improved. What used to be a bag phone on a hilltop with a wire down to a stationary phone is now satellite phone system that allows everyone there with a cell phone to use it. Used to be we just had tied into a phone, kept it in one building, kept it in another building. Now it's progressed to where anybody can tie into our system through the Wi-Fi.
So
So I
do you have
can
like
call
an
out of
internet
the,
line, or how do they get it, how do they get Wi-Fi up there?
it's through satellite.
Through satellite?
Yeah.
Okay.
So we have,
So we have satellite Wi-Fi.
we have a primary system and we have a backup system, two separate, completely separate satellite systems. We actually have, access to radio as well.
Okay, so you do have radio.
We developed one years ago actually it was search and rescue that built it for us. And it can tie into almost every police and responder from Tahoe to down here. We've never actually put it in place because it's just sitting there. We've never used it because the primary phones work so well. People are talking on their phone with somebody in New York all the time. I mean, we now have gotten to the technology that if there's a need to call somebody, but I would say we have at least two, maybe three systems independent of each other that we can use to call for emergency.
So the last 6-7 years have helped you come into compliance.
But it has developed a system that's much easier than having just a phone sitting somewhere where anybody can go call.
Is there any lighting along the roadway, or is that necessary in the case of an emergency occurring at night?
No lighting along the roadway.
Emergency vehicles could get in, or?
Well, it's basically a one road in, so
Right.
it's gonna be hard for them to get lost. Access, signage on the highway is probably our biggest concern. With the new conditions, we think it'll improve. We'll be able to actually put a small two-sided sign out on the Caltrans easement so they can find, right now our sign's set off a Caltrans easement, set back, and so if you're not actually looking as you're going 60 miles an hour, you're gonna miss it.
There's
Let
the
somebody
wooden bear
pull your
too.
bear.
Yeah.
Yeah, we
So
have a
is
problem with-
Caltrans gonna permit that on the
Well-
scenic highway?
It allows for that as long as we stay within a certain size.
Okay.
And I have actually contacted Caltrans about possibly putting it on the other side of the highway because that suggestion might be more easily available for people to see.
Because, somebody driving by might think it's just for the general public. I mean, you're not really open for drive-bys, are you?
We get them all the time.
Oh, okay.
People are curious.
All right.
So they come down and we explain what it is. We typically will give them a tour.
Even future county supervisors.
Yes. People stop by all the time. So it's,
You're not like serving beer and food and all that too?
we do not do any of that. We provide a facility, somebody puts on their own party. If they provide beverages or food, it's all between them and their guests, we do none of that.
In regards to amplified music, I guess 6 p.m. to 2 a.m., but I guess it does reference the general plan, decibel level, plus our nuisance noise ordinance. If you're in there 2 miles, does the sound travel beyond that?
Sometimes a little bit. No, I don't think you can hear our music. I can sometimes hear the highway up by Shot Rock, big trucks or something, but 2 miles through valley and hills there's a hill between us and the highway going towards any. I have never seen it. I'd say there's more noise, more radio noise, music noise off of cars on the highway than there would be from us.
Okay.
But we're also, to be honest, the music is inside a building, so it's muffled to begin with. We're never going to exceed the county requirements at the property line.
Mr. Munn made a comment on that in his June 5th letter on condition 14. Faint music from the hideout has been heard on quiet nights at the Corral Flat Cabins, about 2 miles from the hideout, but this has not been a problem.
If the conditions are perfect, I guess you can hear things a long ways away, but the highway noise is going to far exceed what we produce, if you can ever hear it.
So how long will it take to meet all these conditions?
It will take some time. We will be working on those through the summer. The important ones are fire, road, emergency plans, getting the permits through the different departments of the county. And we have not, some of the stuff has been started, but we have not pursued it because basically we were told not to do anything until it was approved. So do not start asking for a permit prior to, like we'll have to get a small water system permit from the county. If you never approve this project, I would never need that.
Right, so the really important things probably need to get finalized fairly soon.
As soon as possible.
Let me
give you an example.
Are we talking like 1 year?
I would think this summer we'd get almost all of them done, but I don't have control over every department in the county, nor do I have control over Caltrans. So if I put an application in to widen my entrance, I have no idea how long that will take to be processed.
So that's for the Caltrans encroachment?
Yes, the entrance.
Okay, but I was thinking more of the safety issues.
The fire
all the
department,
road work done?
The fire department will be in there. There's time limits on the issues. We have to have certain things done in place for our yearly inspection, which will be prior to the first event.
What about the creek crossing? Are you required to put in an approved creek crossing?
Right now, we just drive through the creek. It's a rock ford creek crossing. Someday we'll have to go back and address that, but it's going to be it'll be an issue.
Yeah.
But typically the creek is dry most of the summer. This year, obviously not. We're still battling 3 feet of snow all the way in. So it's going fast, but it's not fast enough. We've had to ask a few events to move back later into the summer so that we can give more time for the snow to melt. We have somebody plowing all the time.
I've got a question for Krista. On condition 39, talks about water quality. And somewhere I saw where it talked about Bear River being an impaired waterway, which that's an impaired waterway. But I don't know what's a good one. like Bear River's a really pretty good waterway, in my opinion. They're having them sample the pond weekly, the water quality?
That's if they do use it as a recreational swimmable pond. So from what I understand, when I talk to environmental health, this is their condition. It basically just needs to meet the minimum safety requirements for a swimming pool, essentially, so.
Do they do that in like Lake Pardee and Comanche and all that?
I don't think people are supposed to swim in Party. I don't know.
A lot of those, they're swimming in all those lakes.
Yeah, I mean, you would have.
Bear
to
River,
talk to-
whatever. Bear River's kind of cold. People swim there.
Yeah, and I did want to say, so, the Bear Creek Reservoir, whatever, the impairment or whatever, it's from the EPA, so I'm not sure.
I know,
what-
it's.
Yeah,
it's
I'm not
fun.
sure what the parameters are for determining it as an impaired water system, but.
Is this something, that they have to do? Or, do we have, is it required, we can say, that, it seems to me like it's overkill if I ever seen it.
It's a condition for if they do utilize the pond as a swimmable recreational facility, so if.
Is this something is this something we legally have to put onto them?
I believe so, but you should probably confirm that with environmental health, because they are the ones who wrote this, so I believe it is from Health and Safety Code for swimmable bodies of water.
I'd like to ask environmental health, because it just seems kind of ridiculous, really.
I would agree with you, and also that I doubt that Bear River or Silver Lake or Caples has the same condition. We all know that those are used to swim and recreation. Ours is just it's a small pond, maybe an acre. They swim in it when the heat of the summer's on, but after that, it's too cold.
Basically what I see is we're putting you where you got to be spending all kinds of money or doing something illegal, putting you almost in that position.
I don't know what the conditions are for a swim pond. It surely can't meet a swimming pool. Because swimming pools have chlorine and everything else, and they're not obviously going to want me to chlorinate the pond. So I've yet to see what the conditions I have to meet. I can do the testing, but I don't know what the number. It's something new I've never heard of that you have to meet.
Is it the pH they have you test for?
No idea.
No, they're testing for total coliform, fecal coliform bacteria, Enterococcus bacteria, Escherichia coli is required, and it goes, hope I got this all right. And then, all people, well, the ones that should be. If I'm looking at that, I'm going, wow, it's.
Well, fails just no swimming on the pond.
Well, if we find something that's hazardous to people's health, I would think we'd put the no swimming signs out, but, not a huge issue, but people come to enjoy the mountains, and swimming in a lake is part of that.
I believe EH should be sending in a representative.
So I noticed there's a lot of, environmental, conditions here, from species status and, trees, plants, wetland riparian. Where are we in all of that kind of stuff, and meeting those conditions or satisfying? I guess CEQA, this comes out of the CEQA.
So most of those conditions would apply to future ground disturbing activities, so from what I understand.
The parking or the overflow parking.
Right, the only thing that would really, I think, have the potential to impose those conditions would be any additional work that they need to do to support the permitted uses under the permit, or,
So if they wanted to expand operations, they'd have to.
well, they aren't allowed to expand operations under the use permit. This is, the use permit definition and what's been applied for is their current level of operation. So if they had, I guess, something failed, a pipe burst or something, and they had to redig or something like that, that would probably not impose it, just because, I'm not sure, it would really depend on what they're coming in for, and if it's considered
I would think
under the existing level of what's operational, so.
Were those
I think
conditions being met now?
I think those conditions are really for anything future. If we were to put a new building up, if we were to, do something on the property, we would need to review those conditions.
That would require an amendment of the use permit.
And that's what I'm getting to, which is kind of silly, because we have conditions for future activities, but yet the permit doesn't allow it.
So are those conditions all met at this?
Yeah, we've had the surveys done they've all, through the environmental assessments and so on, cultural, environment, and wildlife is all, most of those we don't have on our property, but they're listed in the Sierras or in California.
My name is Joel Riley with Environmental Health. I guess there was a question about swim ponds and testing.
Yeah.
Wondering where those.
We do.
Those are us, but
Oh,
like
okay.
the specific like language of what they need to do.
Yeah. Yeah, so we have, one in particular is, a swim pond at Lake Amador. And, when they're open, during the season, they send in, water quality samples from that swim pond for, total coliform bacteria, E. coli, and fecal bacteria.
Is that a county requirement?
It is for that swim pond. We've been doing that now for 30 years at least, maybe
And
longer.
how often does it need to be done?
During the season, I believe they send them in, every 2 weeks. And then we also have a swim pond at a camp up country. And, they're now also sending in those sample results when the camp is open for use.
Is that like, Lake Amador?
No, it's way up by Silver Lake. I can't remember the name of the camp. Pie Valley, actually, is towards where the camp is.
Oh, okay. Because I'm thinking like the Girl Scouts camp on Lake Amador.
Yeah, no, not that one.
Okay.
Not that one.
I think, doesn't this condition say it's required weekly?
Yeah, it does.
Could it be modified to bi-weekly or every 2 weeks?
I suppose it could, yeah.
Any other questions for environmental health? Environmental, excuse me.
Yeah, is that the only other, are those only ponds or lakes? I'm just looking at, I can see, now Comanche, you're probably getting hotter weather down there, or Lake Amador down in that country, but, I'm just thinking, I see people swimming all over the place. Some of the places down in Comanche, I know one time I was like, man, I wouldn't swim in that if it was me, but people were.
Yeah.
There was a geese out there, and it looked kind of ugly to me, but they all seemed pretty happy, and I don't know if I'd advise it, but they were.
Yeah.
And I see people swimming all over in Salt Springs, down there below Salt Springs Reservoir. And is it a county ordinance requirement, or how's that work as far as just having this put in place, or environmental health requirement?
Well, as far as I know, the requirement for Lake Amador has been there quite some time, like I said, at least 30, 40 years probably, since that pond's been there.
And what was the basis for the county requiring that? Was it a use permit, or?
Well, we permit that pond like we do a public swimming pool. The only difference is with that pond is they have some extra requirements based on the fact that it's surface water and not treated.
Okay.
Thank you, sir.
Sure.
Appreciate it. We have a couple people on Zoom.
Mr. Sweat's been waiting.
Yes, Mr. Sweat, please go ahead when ready.
Yes, thank you. Thomas Sweat for the applicant. I guess I raised my hand a while ago in response to Mr. Gillette's comments on the conditions suggested by Mr. Hoover, and I agree with his opinion and take on the subject. Mr. Forrester had earlier hoped that we might be able to avoid litigation by addressing those, and unfortunately that was previously part of Mr. Munn's strategy. He's already sued us. But the three conditions, other than the 2, 3, and 4, very well could be a framework for us to resolve that litigation. But they really are litigation based and related, and for a private agreement between the applicant and Mr. Munn. And we're happy to, and actually I'm looking forward to engaging with his attorney on that subject, and we may, there may be an end in sight for that piece of it as well. But at present, we're ready to go forward. It's, as been pointed out, it's been a long process. There's some extensive conditions, but they're they're there for reasons. We think we can comply with them. We know we can comply with them. And we're ready to hopefully move forward, having resolved this issue once and for all for everyone. So thank you.
Yeah, because, Mr. Sweat, Mr. Hoover said item 2 on that list, he agrees with, that, the hideout entry and roadway improvements on my property must be available for my use and future owners for legal purpose, so.
Right, and
it's really three and 4.
You're, Supervisor Axe, you're correct. I mean, in principle, I believe that makes complete sense. It's a non-exclusive easement, which means that not just the property owner, but any easement owner could use it as a matter of law underlying that. There's a general background civil code provision that deals with shared maintenance with respect to an easement, that your obligation for maintenance is by law in proportion to your use of the easement. But again, in context of discussing how we could resolve the it's ancillary to this proceeding, litigation that we have with Mr. Munn, I think my client might very well be willing to say, not only can you already use the road as you'd like, but we'll maintain it and we won't ask you for a contribution under reasonable conditions. I mean, I'm sure day to day and as currently situated, that makes total sense. If Mr. Munn were to build a Walmart on his property, it might not make sense anymore. But that's something that I think we need to flesh out as we discuss, on what terms and conditions we might be willing to settle the existing litigation with Mr. Munn.
I thank you, sir. We have one more.
Thank you. We do. Ms. Feeney, go ahead when ready, please.
Hi, thank you. Had a heck of a time getting my hand up here. I have maybe 3 brief questions and then just one short statement. One of the conditions calls for biological survey and mitigation recommendations. And I'm just wondering if there will be an opportunity for public review of the draft mitigation plan. Also, the question about the stream crossing, it seems like it's really an absurd situation where one agency required something to be put in, another one required it to be taken out. And my question is just, who is responsible for figuring out what kind of stream protections will be put in place and how and when will that get done? And the third question is, since it seems like the conditions have written out any requirement to have a fire truck with people trained in CPR and firefighting on site, is this project going to comply with the State Board of Forestry and Fire Protection's minimum fire safety regulations that were passed last August, and apply to development in any fire-prone area, but in particular state responsibility areas, which this is in. And yeah, just my comment is, I want to commend the county for coming up with conditions for this project. I know it's been a completely awkward situation where something was developed totally illegally and they're trying to backtrack and make the county code and general plan comply with it way after the fact. But I think it is important that there are these protections in place for the environment and for public safety in particular. And I hope that the conditions will be met before the Hoover hideout is allowed to continue its operation. Thank you for the opportunity to comment.
Go ahead, Mr. Sweat.
I guess in response to those questions, that the biological conditions are in there, as was earlier pointed out, to cover the need for any future ground disturbance. There's none contemplated with the application. It's not an application to expand, but otherwise to permit what everybody thought in good faith was compliant with the code, and to a certain degree settle and not have to enter into some sort of dispute about the interpretation of the zoning code. So we haven't gotten here by a deliberate and willful intent to violate county zoning code, but we're happy to have gotten to the point where we can resolve this, and there's reasonable conditions in place that we can comply with. when you look at the biological conditions, it's very common in this situation for them to require surveys and to develop monitoring plans based upon the results of those surveys when and if any disturbance is required, so that you can do what is specifically needed on the ground at the time that the ground is actually disturbed. So the regulatory agencies will be the ones to determine what that ultimate plan would be to mitigate any necessary disturbance. Unfortunately, there was miscommunication between various levels of Fish and Game regarding the stream crossing. And as Mr. Hoover described, the inertia of the whole process just finally made it easier just to take it out. If a bridge or some other structure was later proposed to replace that crossing, that's again something to be permitted with respect to the county, to the state, Fish and Game, and they have their own permitting processes for doing that when and if that were to ever be the case. Right now, it is a gravel ford, not an uncommon means of crossing an ephemeral stream like that, and it's been approved and by Fish and Game, who approved the plan to remove the crossing and replace it with that gravel ford. So at present, we're in compliance. If there was a replacement structure that was ever brought forward, again, that'd be a permitting process primarily managed by Fish and Game. With respect to fire, it's been a long process. We've been extensively engaged with Amador Fire District to make sure that we satisfy their concerns. We've got the, I guess, parallel tracked application for deviation, but we have cleared and vetted the process, and it's reflected in the conditions, as planning pointed out, to make sure that we're doing everything we can in the site-specific way to make sure that the hideout is as safe as possible from a fire perspective.
Thank you, sir.
I have just a question primarily for County Council. So what's the county and the board members' liability for not enforcing the conditions? Because all the conditions haven't been met at this point, but Mr. Hoover does want to operate. Also, if some of the environmental conditions are not met, and would we be violating CEQA? I mean, that's kind of where things are. There are all these conditions, they're not met at this point. I don't know when they're going to be met, 1 year, 2 years. What's our exposure on all of this?
Well, I mean, that's kind of a hard question to answer because we don't know what might happen or what, but generally.
Well, for example,
you're not,
say the place burns down, people are killed.
Generally, the county is
would
not.
Would we be liable?
So generally, the county is not responsible for decisions about what, like enforcement decisions. Like a prosecutor is not liable for charging someone with a certain crime, and I mean, those are discretionary decisions. So I don't think there's liability there, but that doesn't mean someone couldn't or wouldn't sue the county if something like that happened. And your other question was related to the environment.
Well, if we didn't enforce the environmental conditions, make sure before operation occurs, would we be violating CEQA at that time?
Well, it's sort of a continuation of what's always been the county's practice, which is, if maybe someone's not in compliance but is moving toward compliance, we don't shut them down. It's really the same. Technically, their use permit won't be effective until all the conditions are met and their use permit's issued. That again is sort of an enforcement decision by the county, and the historical practice of the county is, as long as they're making progress and they're moving towards completion of all the conditions, especially the ones that are safety concerns, then perhaps the county wouldn't would move to stop the use, as it's done since this came to light.
Chairman, Bruce Veraco, clarification. The conditions of approval are also incorporated into a mitigation monitoring plan, and it specifies which department or agency is responsible for each of those conditions. And so that's an automatic process. They would be the ones that are responsible. Whoever's listed on that condition is responsible for that condition.
Thank you, sir. Mr. Munn?
John Munn again, with clarifications. And Mr. Hoover has spoken for me, and I'd like to clear some of that up. But first, the deviations, that's a county process. And I was just pointing out that if you're going to have a county process, you go through the county process. And it just doesn't appear that you have. And actually, that's your process, and that's for your protection. I don't care. Both the roadway on my property and the hideout entry must have needed agency approvals and meet all legal requirements. I want to, that I stated was covered by the conditions, because essentially those are what the conditions in the use permit show. Why do I think it's important for me? It's because the entry currently isn't indicated by Caltrans that it needs to go through decertification. And if that's true, then Caltrans has been lying to me for 20 years. Okay. I'll take whatever Caltrans says is needed. There is no permit. There is an entry, and that entry got a repaving permit back in 2006, I think it was. And when it got that permit, it was based on the misinformation that was, I guess, provided by someone to Caltrans that there was a break in the Caltrans right-of-way. There is not. And that Caltrans specified that it would be used as a driveway, and therefore, it was not going to carry very many vehicles. Well, it's kind of changed from that. So there's also the little issue about grading permits, and that's a county issue. I don't think there have been any grading permits, but there has been a heck of a lot of grading on the roadway to the hideout. So I want all that done legally, properly, so that if I want to use the road in the future for some other use, somebody doesn't say, hey, you can't use that road for that, it's not legally permitted. Well, I just want it done right, that's all. Now, this use without recompense, if you read those conditions, one of those conditions talks about a road maintenance agreement between users. Well, I don't see any reason that I need to be paying for taking people to the hideout. That's all. 3, future modifications. Now, you can characterize me as being disagreeable, but it's always after the fact. A change is made, and either I got to like it or shut up. Now, some of them I didn't like. That crossing we talked about. I worked for California Department of Forestry for years and years, and when I looked at that crossing, I saw immediately that it would not be approved by either CAL FIRE or by Fish and Wildlife. Now, both of those agencies have to buy off on a timber harvest plan. If that timber harvest plan were to want to use that crossing that wasn't approved by Fish and Wildlife, didn't meet their requirements, they wouldn't let me use it. Well, where is that crossing placed? It's placed in the ford. So I don't have any way, without building another ford somewhere else and going through the process of getting that approved, of yarding timber products through, or trucks. I mean, a truck carries a timber product. It couldn't have used that crossing either. And that wasn't going to be approved in the timber harvest plan process. So basically, about 1/3 of the property was shut out from using that crossing to bring forest products across. And it was originally built as a logging road, Now, that crossing was installed without talking to me. If he'd talked to me, fine. I would have suggested that he move his crossing somewhere besides the ford. But not talking to me ahead of time, I just found that when I had to walk down the road because he'd locked a cable across the road, so I couldn't even drive down the road that was on my property. Okay. So I guess I'm the bad guy because I don't like things after they're done. And this quiet title thing, I recognize that items 2 through 4 would be difficult to put into county language. But I need this agreement in order for me to live with Mr. Hoover and the hideout. If this doesn't happen, then it's to my advantage that the hideout not be in business. Mr. Hoover did ask or tell me that he had a prescriptive easement to another parcel. And then he took big, heavy equipment in there and he opened that easement without talking to me about that. Once again, am I the bad guy? Not that I know of. So if Mr. Hoover wants to do things on that easement, I would like to have him consult me. That's all. Oh, and by the way, the utility right-of-way, that exists. So if he wants to run power to the hideout down that easement, he's got it. So,
Thank you. Hey, we don't have any more comment. Motion to close the public hearing.
Oh, hold on a sec. So, just to Mr. Munn's point, you don't have to enter into a road maintenance agreement. So it just says the property owner may enter into a road maintenance agreement. It doesn't say that it's a shall. Okay.
Okay, do I have a motion to close the public hearing? Move. Okay. Do I have a second? Call for the vote. In favor?
Aye.
Aye. Opposed? Okay, back to the board for discussion.
Yeah, lots of comments on this.
Yes, we have.
Back and forth, and I appreciate Mr. Munn's concerns and other people, and I appreciate that business are being conditioned to death. So there's got to be some, I would call, middle ground, and I think the planning commission is to be commended.
Commended, yes.
For doing quite a bit of work on this. Has been, ever since I've been on this has been on the agenda since I've been on the board, damn near 2 terms. So there's no more discussion. I'm ready to make a motion.
Well, I would like part of that motion that this come back annually to the board for consideration of whether the conditions are being met and have a review of that, because I'd like to see them get met. Mr. Hoover plans on operating this board. This county seems to allow that to occur.
I think we have a lot of, regulatory people that will be evaluating this.
Yeah, but I just want to make sure they're not all done. So, usually you apply for, you get approval, you get the conditions met, then you start operating. So I think it should come back annually to this board to review.
That could be an ongoing process too of the agencies responsible, county departments responsible for monitoring to provide maybe every 6 months a report to the board on compliance. And I agree, it can come back to the board then.
Okay.
I don't have any problem with that.
Condition 39, environmental health indicated they were acceptable. They're going to, says it must be sampled weekly. So it could be changed, it must be sampled every 2 weeks.
Yeah.
Bi-weekly. Also that, condition number 4, like item 7, I think that should be changed, ACES and or successor or franchisee or whatever's up there. That should be changed.
Wherever the current waste hauler is.
Yeah, we're good with it.
Are you okay with those 2?
Yep.
3 addendums.
3.
Yeah, and we can't put some of Mr. Munn's requests into the conditions, but I strongly urge Mr. Hoover and his attorney to work with Mr. Munn to some kind of resolution on 3 and 4, because it seems like 1 and 2 are satisfied.
Right.
Okay, do we have a second?
I'll second that.
Call for the vote. All in favor?
Aye.
Aye.
Opposed? Okay, that's a 5-0. We're on to 5D, appeal the Planning Commission's approval of mitigation negative declaration and tentative subdivision map, number 187, Oswell Ranch Estates, proposed division of 61.27 acres, property into 6 residential lots ranging in size from +5 to +33.6. Yeah. Let's get through this one and then
Okay.
we'll go to lunch. Yes?
Nicole Shepherd with the Planning Department. Like you said, this is the appeal for the Planning Commission's approval of the mitigated negative declaration and the tentative subdivision map 187. A little bit of background on the project. On February 16th of 2023, the Technical Advisory Committee found the application complete, and on March 16th of 2023, TAC found no technical objection to the Planning Commission approving the tentative subdivision map, subject to the mitigation measures, conditions of approval, and findings, along with a recommendation of a mitigated negative declaration as the appropriate environmental document. The Planning Commission, following a public hearing on May 9th of 2023, approved the tentative subdivision map, Oswell Ranch Estates, and adopted the environmental document, a mitigated negative declaration for the project. An appeal was filed on May 19th of 2023, appealing the Planning Commission's approval and the MND and the approval of the tentative subdivision map to the Board of Supervisors. Tribal consultation was requested by one tribe, the Ione Band of Miwok Indians, and recommended mitigation measures for the project were included in the conditions of approval. If the board moves to approve the project and deny the appeal, recommended findings are included in the staff report.
The proposal here is for 6 parcels, correct? So why in the document are they only required to show that 2 wells will provide adequate water supply?
That condition was proposed by the Environmental Health Department. So as part of their conditions, they only brought in the 2 wells.
I think water's the big issue out
Yeah,
there.
I do too. I was surprised that under the hydrology and water, it's less than significant on impact.
Under the conditions there that, or under the document, water well quality supply, I was really surprised, and it's cited, Sarah didn't give me enough time to go through my documents, but it's cited under as less than significant, but the measure that's being used is not really on adequacy of water. It's more, looks like on biological to me. I can give you some specifics. Says that the mitigation measure HYD-1, but that mitigation measure is just grading permits and erosion control. So to me, it doesn't apply to, is there going to be enough water for those people? And to say that you put something in the title report that you may not have enough water here and you may have to pump water in, to me, that's just dead wrong. you're setting people up for failure. Gives people no quality of life. I mean, in my area where I live, all up and down Willow Creek Road, there's a lack of water supply. And I don't know how we can logically approve a development in an area that's already very stressed. And then you're gonna tell people that they can haul water in to be able to live? Because, all the neighbors here have gone dry, their wells have gone dry over and over again.
Yeah, existing wells are going dry.
That's right. I know it is.
How could you add to the load? That's a serious question.
No, it's a problem, especially the density. I mean, like you go down that Willow Creek subdivision, there's some wells are good there, but a lot of them are really bad. Right across the road, way real close by, you got the Greelage Ranch. I think they must have drilled 50 holes down there, and most of them had dust or minimal water. So it does concern me trying to put that many lots down there. I don't see it, or parcels.
Also, I gotta find this now. The Foothill Resource Management, Mr. Cannon, in his statements, I think he indicated that, I want to make sure I'm correct on this, that the owner of the property stated there would only be 4 parcels. I have to look at that and make sure I'm correct on it again. He says the proposed subdivision would establish 6 parcels. In discussion that I had with Ms. Chantel Crawley, she told me that her intention is to sell the 4 parcels for residential development. So if she sells the 4 parcels, I guess she would still have 2 other parcels, because his recommendations here, or his professional opinions were all built on what he was told by the owner of the property, as far as the amount of trees that would be removed. So I'm not sure his assessment is correct if we're talking about 6 parcels instead of 4. Maybe I'm just confused. He does say up higher that there would be 6 parcels, but then in Ms. Chantel Crawley's intention was to sell those 4 parcels for residential, so would she be keeping the other 2 parcels?
But they'd still need a well.
Well, that affects his whole study on oak woodlands and the amount of trees that would have to come out, have to be preserved, or once some of them are taken out. I mean, his whole opinions are based on his understanding of what's going to occur. What happens if something different happens?
I'm not aware of the intentions of the applicant, but I do believe she is on Zoom if you would like to direct that question toward her. Or as well as I do believe her representative, Toma and Associates, is here as well.
That's one concern, but the bigger concern is the water for me.
Go to public comment. Mr. Forster, are we ready to go to public comment? Okay, let's go to public comment.
Good afternoon, Mr. Chairman, members of the board. Matt Toma here representing Chantel Crawley, the applicant who I believe is on Zoom. At least she was going to be for any questions for her.
She is on Zoom and she is unmuted, so she can speak.
Okay. Supervisor Forrester and Chantel can correct me if I'm wrong. I just want to answer your questions. I believe what her intention was when she said she was gonna develop 6 parcels, she was gonna keep 2 and then sell 4. So I believe when Steve Cannon did the analysis, he wasn't analyzing that 6 residential parcels would eventually be built.
That appears to be correct if reading down in the document further.
Right.
I thought I had read that earlier, but I want to make sure that's the intention.
Sure, absolutely. And then as far as, I believe someone from the health department's here, the 2 well requirement, just from my experience doing this for a long, long time in this county, proof of water on a multi-lot subdivision like this, the county's policy was always 1 well per 4 parcels, for something like this. So I'm assuming, they can correct me if I'm wrong, but I'm assuming that's where that came from. Yeah.
That's, might be a long-standing policy, but after 5 years of drought.
I agree. Yep. Thank you.
I'm Dana Farias, and this is Larry Mazzanti. We're both neighbors of the adjacent property.
Can you speak right into the mic?
Sure. We're neighbors of the proposed subdivision. So first, I want to thank all of you for listening to phone calls that we made. It's really quite impressive, and taking the time to look through the documentation. So I do appreciate that. We're here because we really feel like the current proposal is inadequate and has a lot of shortcomings. You know, if this were just to put a grandmother house on the property or a couple houses for family, that's one thing. But putting in a subdivision where there's known lack of water is very fearful for us, and it's also a potential limitation for the people that buy the property. So to give you some background, the prospective buyer of the property before Ms. Crowley bought it their plan was to put in some vineyards. They've dug approximately 4 wells, 3 of which were dry, 1 that yielded some water, but was inefficient. He walked away from the deal, said there's no water here, and he left that property. All of our wells continually go dry. We all have storage tanks. You wait it out, it refills. My well is 560 feet deep, so it's not like we're talking about surface water here. And our fear is that adding an additional 5 or 6 straws into this aquifer that we really don't know the depth of it, how much water's there. What we do know is that there's a lack of water, run out, and we're very fearful that if this happens, it will render our own properties unlivable. And also cause the subdivision to fail. So it sounds like it's, given the limited water resources, the grand scheme of putting this number of houses in this small area where we know there's no water is very concerning. So I hope you take that into consideration, and I appreciate you really thinking about this.
So you said,
Yeah.
I think the previous owners was Mary Ann, was it Rittenhouses, I believe? Previous owner? Mary Ann Rittenhouse and her husband?
They were out in Davis. So it used to be cow pasture. So it was all for cow pasture. And then there's an individual that came to buy the property, that wanted to put in vineyards. And he started drilling wells. He didn't purchase the property. I think he put a down payment. He put, multiple wells on the property to try to find water, and he couldn't get it. So he walked away.
6 or 7.
Yeah, it was a lot. I mean, they were out there for a bit.
You know, that'd be something, I'd be kind of curious to know if environmental health would have any record of that.
Well digger, I don't know who dug them.
Well, normally a well has a well permit issued a lot of times, not always, but a lot of times. Supposed to be at least.
Yeah, they dug a lot and they couldn't. I mean, there's multiple areas where they dug and couldn't get water. He did eventually, I said, get some water, but it was insufficient still. He just walked away.
6 or 7 wells, they had 2 that had a little bit of water. One had a little bit of water, not even enough for a well. The other one would have probably made a well. It may be 2.5, maybe 3. I'm not sure. I wasn't, just hearsay. But I've lived there for 45 years. I've dealt with this no water to low water at all. And it's just not there. My first well was drilled in 1978. I had trouble with it. It kept going dry on me. I built a home and I drilled another one in 1992, which is maybe 2 gallons. The other one was 2 gallons. Between the two, I can juggle them back and forth and maybe barely make it. I've had them both go down at the same time too. So you never know when they're gonna go. It's just, it's a horrible feeling, you know. You get up some morning and put the coffee on, there's no water, you know. But, that's true. That's, you know, when it gets real bad, when it gets real low in the aquifer, you get a lot of calcium. It really builds up strong. That's a horrible thing to have. And when I asked the planning commission, I said, what are you gonna do about the water? Oh, we're gonna drill wells. I said, there's not enough water out there. She said, well, put tanks in. Well, somebody's gonna have to fill those tanks. That costs money. And it's not gonna be good for any residential people out there at all, that I could see. If it was, I wouldn't be here. That's about all I have to say, sir. I thank you for your time, and I don't know
Thank
what to
you.
tell you.
Yeah, it's one thing I visited the Big Island, Hawaii numerous times, because it's a volcanic island. Half the pickup trucks have water tanks in the back of them.
Yeah.
They go into the city, fill them up, come back home and fill up their,
Absolutely. Even the rancher that had cattle down there at one time, he had to bring water in from time to time.
right.
And there's only one person in the county that I know of now that delivers water to these places. They had two, there's only one now. Thank you, sir.
Thank you. Okay, any other public comment?
Hi, this is Chantal Crowley. Can you hear me?
Yes, we can.
Okay. So I just want to clarify a little bit. The property that I want to subdivide that you're talking about, there are two wells out there. One has a permit and it's up on the top of the ridge. I've never had a problem with it. There is another well that was drilled and put a sleeve in, and it has water, 7 feet down, you hit water. The owners that I bought it from, the Zimmermans, they had, as they stated, my neighbor stated, there were some people that were going to put it in vineyards and 2 houses on that property. They had a testing company come out and they had a drilling company come out, and they did drill. But as you know, with vineyards, it takes a lot of water. There wasn't enough water for the vineyards, but there was enough water for houses. And based on the fact that we are going with the current codes and standards for dividing this property, it requires 1 or 2. I'm kind of confused now after you're talking. There are 2 wells out there. They both have water. I don't talk with my neighbors about their water much, but I know Larry, who just spoke, told me he has 2 wells, and he ran out of water the other couple of weeks ago, he said, because he left it running all night. But my neighbors that are not there, or maybe they are there, haven't spoken yet, they have their well on my property, and there's an easement, and that was established back before I bought the property. So the issue of wells is that there are wells out there, they're producing. I don't know, Dana, who has a property over the ridge and down, has a donkey sanctuary. And all my neighbors have animals, donkeys, cattle. I have nothing out there right now and don't plan on having it. But you know, I was told when I bought it from the real estate agent that was representing the Zimmermans that yes, there were wells dug out there, test wells. They all had water, but not to meet the minimum they needed for vineyards. So I'm asking that you look at this project with the guidelines that I have met all of them. Matt Toma is working for me, doing his due diligence to meet every requirement. We had an appeal on this from my neighbors, and I just ask that you look at it with the current situation of the rules and guidelines that we have followed to a T. And I just ask that you approve this for me. Thank you.
Thank you.
Years ago, in 1979, Don Matley Jr. had the place just across from me. He drilled 2 or 3 wells. they're all empty. He went down on his father's property right down there, which is parcel 5 on the Chantel's thing here. And he drilled a well there and got a couple of gallons. I mean, that's all he could do with it. Urge you to please vote no on this. This is no good for the people coming in here.
Thank you, sir. Okay, we have Zoom.
Thank you. Mr. O, please go ahead when ready.
Hello, Matthew O. I am the other neighbor that the applicant is referring to with a deeded well. Myself and Lewis have a well on her proposed parcel 5. I'm wondering if you could refer to the map 1 that I included with the appellant's materials. If you could put that on the projector. Please let me know when it is.
We don't have that ready right now.
Oh, okay. It would inform the Board of Supervisors greatly if they could see it, because our deeded well approximately falls right smack bang in the middle of the proposed parcel 5. It occurs in a natural swale on that property and next to parcel 4. So all the other parcels in our properties basically flow down into this basin below Highway 124. It is what we can ascertain from California Fish and Game, a vernal pool, and it hasn't been recorded on any of the applicant's maps, nor our well on the applicant's map. So whatever well setbacks there are, we also feel like these setbacks should be even larger because it's not a private well on a private property. It's a neighbor's well that occurs in a vernal pool where any kind of sewage or septic leach fields will pool into these vernal pools and into our well, raw sewage. Now, when the applicant says she's never had a problem with her wells, our well is on her property. It has run dry. I don't think she's listening. It keeps running dry every summer. Now, life and property values are high stakes here. And looking at current codes or whatever it is the applicant is begging you to do, it is insufficient in this location. When she says, I've never had a problem with it on her wells, her well is up on her property on parcel 3, and she doesn't have a building permit. She doesn't live there. So of course she doesn't have a problem with it. When she does occasionally come to the property, I'm sure it's running. Now, in terms of doing everything by the book and approving this on that process, I find numerous inconsistencies in the report that was produced by Nicole Shepard on behalf of the applicant by the Amador Planning Department. It does come to a shock to us as neighbors in this small community that a report would be prepared by the local planning agency on behalf of a private developer. One day we go down to the mailbox and find out that the applicant is trying to subdivide into 6 properties. The inconsistencies, as noted by a Board of Supervisor, where some of the report was done for 4 parcels, later glossed over, oh no, it's 5. In the report, there's 5, which means that she's leaving herself the option to further subdivide her parcel 3 into 6 more. In a private conversation with the planning director, Chuck Betty, last week on June 6th at 4:30, he told me that the maximum yield for this zoning is 12 properties, and thus the applicant's proposed 6 is a significant mitigated measure. Thank you. This is the map that I'm referring to. In terms of feasibility of how you could build on these parcels, which is, if I could read from the report itself, at the very beginning of the report, Ms. Shepard states, excuse me one moment, recommended findings, G, this is page 1 of the report. Given that section 66474, et cetera, to deny approval or a tentative map if it makes any of the following findings. Of them, C, that the site is not physically suitable for the type of development. And she concludes the above findings 1 to 1, A to G, do not apply to the tentative subdivision map 187. In that, we'll go to the same point in response. The site is physically suitable for a residential development and is compatible with surrounding residential and agricultural uses. I strongly disagree with this. I am in architecture and I'm in construction, and I've included for you in this map, which is basically drawn over a map provided by the applicant and her representatives. Matt Toma, who we today just found out is a Amador Chamber of Commerce member. So that's her representation. And of course, he has his own, on top of his surveying business, but his own motivations, we suspect. In this diagram, you can see that parcel 1 has no access from the street. It is heavily wooded. There is a mound that is about 100 feet tall. Now, any driveways that you would have to put in, I don't know how they haven't proposed anything, so no building envelopes, no driveways, which require grading. An oak study report that was so ambiguous. It was only for 4 parcels, but here we are, we're trying to analyze this report for 6. Parcel 2, even more heavily wooded. There's no way to get to that parcel without further easements. How are you coming in from the street? Or if parcel 3, you're clearing even more oaks just to get to it, let alone vehicle turnarounds, emergency response vehicles that have to somehow get up to these huge mounds of grades that are somewhere between 5 to 10%. Again, no wells, no power. There's no power on this site at all. You have to go all the way to Highway 16 and then at least 1,000 feet down Highway 124 to draw any PG&E power poles. So the number of power poles that you need to bring just to get power onto the site somewhere, then the number of power poles that you need to add just to service the site, the terrain to put those power poles in, the fire risks that come with these the power poles.
Sir, you live nearby, don't you?
Correct. I live on the very bottom right parcel down there under parcel 6. Myself and Lewis.
Do you have power to your property?
We do, and we're also switching to solar because of the incredible risks that PG&E power poles bring. Every summer, we fear.
Yeah, so how'd you get power to your property? I mean, must have come a long way.
No, there is a power line that is beyond our property and Larry's property in the pastoral property adjacent. That's where the power runs. And it came with the property.
Not saying I'm for or against this project, but if you want to be a good neighbor and lessen the danger and lessen the length of the line, you could probably give them access to power through your property then.
Why would we want to bring that fire risk?
You put one in there already, I mean.
So.
I'm just thinking here.
Okay. Am I still on?
Yes, you are.
Okay, I will just wrap up with this map. I do have additional comments later on if needed on the process of how this report was produced. But again, parcel 4 and 5 occur in a vernal pool. You won't be able to tell from any of the maps that the applicant or her representatives have put together because they don't completely show the topography where all this water collects, and it's actually a FEMA flood zone X. It's a recorded federal flood zone with a vernal pool and a year-round pond that's sensitive to all sorts of amphibians, reptiles. It's just deafening in the summer nights, the number of frogs there are in this area. Then you see our well that's located basically in the middle of parcel 4 that's been proposed. All of that water collects. Any kind of development or sewage, septic lines will pool and run down into that parcel 5 where our well is. That's all I have for now. Thank you.
Okay. Go ahead and kill that. Nobody else on Zoom? Nobody else from the audience? So do I have a motion to close the public? Oh, I'm sorry.
Just would like to address some of Mr. O's comments. Regarding the vernal pools, yeah, there is a drainage out there on parcels, I think it's 4 and 5. It does show clearly on the topography of the tentative map. There are county setbacks, you know, for septic, construction, that kind of stuff out of any kind of a drainage. Regarding his existing well, it does exist. There's an easement for it. There are also setbacks for septic, construction, that type of stuff around any kind of well. So we would be meeting any kind of county codes as far as setbacks for all those concerns that he had. And I would invite him, as far as for a subdivision like this, take a drive up to Surrey Junction or some of the other, you know, 5-acre lot subdivisions in this county that are on steeper, more heavily wooded grounds like that have been in existence for literally decades.
Thank you, sir. Okay, do I have a motion to close public hearing?
So moved.
Second.
Call for the vote. All in favor?
Aye.
Aye. Opposed? Okay, back to the board for discussion.
I'd like Ms. Shepherd and Mr. Beatty to come up. Come forward. No, I'm still really bothered by the one issue on water and the availability of water, and then giving it a mitigation measure, HYD1, which has to do with grading permits, erosion control, and stormwater runoff. Where does that deal with water supply at all as a mitigation measure?
Water supply is dealt with in the two of the last conditions, which talks about the 2 wells will have to have a certain yield.
2 wells
in order to get, which is the county. And I know what you're thinking, 2 wells for 4 lots. And when I got here, you know, 10 years ago, I was like, the way we did it was 1 well per lot. But people said you got to think about where you are versus where you came from.
So basically, all they have to
availability of
demonstrate
water.
is they can get a gallon of water or something like that.
And county code allows single-family residential well to have a yield as low as a half a gallon per minute.
Yeah. Which
now,
is
for these wells, and excuse me for interrupting. So she has 2 wells. So out of all this property, there's actually 3 wells on this property, 3 producing wells.
Yeah, correct. Yeah.
Okay.
2 of hers and 1 that's has an easement to a
right. That's right. So half a gallon a minute. I mean, that gives you no quality of life at all. I think when we're approving developments like this, we got to think about that. You see wells in this area, in the general area, and that's going to be the case on these parcels that are going to be going dry. And how do I know that? Because all you have to do is look at the neighbors and the history of the wells going dry on their properties. That was a big concern for the Planning Commission. That's what caused the 3-2 vote there. I think people, when they're doing developments, they need to look at the area and they need to look at that there's already been a lack of water and we're just going to cause problems. And I've had plenty of those problems. I used to represent the Willow Creek area where people's wells were consistently going dry. Who do they call? They call me. Why did the county approve this?
It would be nice to have had some wells drilled out there to see what kind of production they have. But sounds like a lot have been drilled, you know. But that's just testimony. That's not actual physical results. So yeah, I have concerns over the water availability and the density.
And there's county codes and real-life testimony. I mean, you can't discount the neighbors who are dry wells now.
Good afternoon. I'm Debbie, Environmental Health. We do only have 2 records that look like active wells. One's been finalized and one has not been finalized. And then we have 1 record of a destroyed well out there. That's all we have in the file for.
Well, we don't even have 3. I mean, is that counting the easement well?
One is Zimmerman, which is not finalized, but it has a note here of 7 gallons per minute. But I don't have the well driller's log. And then this one is, on Crawley's.
Crawley wells are on the property, they're not the neighbor's well that's on the property.
Oh.
Yeah.
It doesn't say what the Crawley produces?
No.
Probably not much then if it wasn't final.
The Crawley one was finalized and the Zimmerman one was not finalized.
Zimmerman was not, okay.
Oh, wait, I'm sorry. Wait a minute. I'm sorry. Okay. The Zimmerman one was destroyed. The Crawley one was finalized, and the other Zimmerman was not finalized.
What is the producing on these?
Just one of them shows 7 gallons per minute, and that is the one that's not finalized on Zimmerman, at Zimmerman.
That would have been drilled probably, few years ago?
That was drilled in 2018, it looks like, and the permit was issued in October.
And what would be the reason for not being finalized?
I don't know, I'm gonna have to look into why it wasn't final, yeah.
So, don't we need two wells finalized or 2 wells drilled?
So I'm unfamiliar with this policy of drilling two wells per 4 parcels. My experience is having to, prove water on every parcel. That's just where I came from.
That would make sense.
And it doesn't sound like, there's a good history of water there.
Truck's right behind you.
And also, maybe it needs further evaluation by a hydrogeologist.
I was just gonna say that the county's policy has been to have those, 2 wells that produce adequate yield for, I can't remember the math now, sorry.
And is that
We're up to 6 parcels, I'm sorry.
And is that a written policy? Or is that just what environmental health?
I don't think that's in the county code, I think that's just been past practice.
That's what I think is the case too.
The half gallon a minute is county code, but the number of adequate
So what is
wells with yield
adequate
is,
gallons per minute?
pardon?
What is adequate gallons per minute?
I can't answer that, I don't know.
Okay. Two? Okay.
Right. Half gallon a minute means you can't have livestock, you can't, have a garden, you can't do normal things that people want to do.
Okay, it's back to the board. Any other items for discussion?
Move to close public hearing.
We already closed it.
Okay.
My feeling is at a minimum, we need to have each parcel prove out that a well that's sustainable with a well on it.
I think the density's too high, period, in my opinion, if nothing else. I don't see, we're having, like what you said earlier, Richard, about having problems out in that whole general area there. A lot of areas are, so I'm not really too thrilled with doing 5-acre parcels out there when we're having those problems, and neighbors are saying they're having those problems, and I know, that general area down there, they have had a real struggle trying to find water. I mean, I'm inclined either deny it in whole or see about reducing the acreage as far as, number of parcels on the acreage. Yeah, at a minimum. And, you know, maybe, let's see. I know science has been changing on trying to do water hydrology studies, and I don't know how exacting it is now. I know it's always been a kind of a throwing darts at a wall. Could maybe environmental health, maybe, do you have any information on that?
So I'm not super familiar with that area and how it is, but it,
I mean, as far as just the different methods of trying to basically look through the earth to see what's in there.
oh.
That's kind of a hard question, I'm sorry.
Yeah. I think it's a records, you know, they look at the geology of the area and they try and come up with what they think is happening under there. What they know is happening, talking to the well drillers. The well drillers are a really good source of information too.
Yeah, they say that trying to get water out there is really bad.
There's also possibly the possibility of sharing a well.
You're already having water.
With a very tight well sharing agreement.
Very tight.
Very, very tight well sharing agreement. Thanks.
You know,
Okay. Matt?
I know the public hearing's closed, and I know this, just throwing this out, food for thought, and Chantel's online, she can reach through the phone lines and hit me if she wants to, but, you know, it sounds like if there is a true concern with water in an area like this, rather than doing the 2 wells for proof, if you just put it down like Supervisor Forrester said, and literally drill, you know, 1 well, you know, per lot, just to prove that you do have, you know, a source of water for each proposed parcel. I'm not sure if the board would consider that, or if even the applicant would consider that, but just kind of food for thought for you guys.
I'm kind of torn between that and the density issue Supervisor O'Neill brought up, that I think maybe too big of a bite was taken on this property.
Mr. O, go ahead when ready.
Oh, thank you. I know the last public comments. So the issue of water is just so crucial, especially in this area. It's not like we're talking about somewhere in Pine Grove or where there's snow melt or anything like that. We have livestock. Sarah and Dana operate a donkey rescue farm. They have horses and donkeys, a charity that they operate out of Amador County. I just find it ridiculous that earlier the applicant said that because she doesn't have livestock, that she's using less water as her neighbors. And also the issue of sharing a well, I think, is quite ludicrous. Our well down there barely produces enough for us, our family. And you're suggesting that possibly sticking another straw on that parcel will not impact our well at all is very concerning and dangerous to us. Thank you.
Thank you.
I think it's kind of ridiculous that people take too big of a bite on the apple, myself, in an area that's already water stressed.
Right.
Oh, where would the board like to go?
Well, I need a question answered by council. If the board were to grant the appeal and deny the project, would it be sufficient because of the reasoning that the area already has shown to have major difficulties with the wells being sustainable?
Yes, I believe so. So if you look at subsection G of the staff report, it has those findings. It refers to Government Code 66474 about denial of a map. So if you believe that the record, the evidence suggests that any of these conditions apply, then that's the basis to deny.
So basically, we'd be looking at, looks like, under what Supervisor Ornetto said, item D, site is not physically suitable for the proposed density.
There's potentially a few of those might apply.
Maybe C, D, F?
Yeah.
It's something.
Mr. Chair, do you want me to make a motion?
Yes, go ahead.
I'll make a motion then to, reverse the planning commission's decision, or appeal, of this based, the mitigated negative declaration based on the apparent lack of water in the area.
You better cite the findings. I think you said C, D, and F.
Is that in the findings, C, D, and F? And, the findings under, item G.
G, right. Actually be C.
I'll second that.
Need to cite those, C, D, and F.
So what you're finding is that those findings do occur based on sort of the discussion about the lack of water in
Yes.
the area. Yeah.
And you're okay with the findings added?
Yes, I'm okay with the findings being added.
Okay. Call for the vote. All in favor?
Aye.
Opposed? Okay, we're on to, let me rephrase this. We still have one more planning department item on there. I don't think it'll be a difficult one. I think we can get through it. Is anybody? Should be a quick one. So, do you have a problem with that? Okay. Let's go on to 5E right quick. Planning Department, consideration of Planning Commission's recommendation to approve a request for zoning change from R1A, family residential and agricultural zoning, to ag, exclusive agricultural zoning district, in conjunction with request of inclusion into the California Land Conservation.
So yeah, this is a, approximately 281.5 acre parcel, well, multiple parcels, property located at 8869 Tonsi Road, so it is contiguous clump. Its current zoning is R1A, single family residential and agriculture. And with any new California Land Conservation Act, aka Williamson Act, it includes a rezone to our exclusive agriculture zoning district. So past practice, we always include that rezone as part of the application. In light of some, more in-depth CEQA evaluation criteria, we did include some conditioning of the contract to limit those by right uses under the AG exclusive agriculture district to require a use permit. So that would prevent any increase of by right uses that would introduce new potentially significant or impacts that would not be mitigated otherwise. So just to kind of eliminate that from possibility, we just conditioned it so that if they did want to partake in some of those uses under the AG exclusive agriculture district, they would be required to obtain a use permit, which would be a further discretionary permitting process. So with that change, we are able to recommend that the whole project be processed as exempt per CEQA under the open space easements, contracts and easements exemption. I did want to note, so there are, I believe, 3 individual parcels under, included in the project. So one is 106.27 acres, one is 24.02 acres, and one is 151 acres. So when the Ag Advisory Committee did review the application, they did have several scenarios under which the property or they found the property or a portion of the property would qualify under Williamson Act. So ultimately, the applicant chose to place each legal parcel into a separate contract. I know that the recommendation, they were saying that the 24-acre parcel would not independently qualify, so that would very likely be included under one of the contracts. That would be for the larger parcel. And then I did want to also note that the Ag Advisory Committee recommended merging of the parcels, either the larger ones or I guess all of them under one or the larger ones under a contract. But I know the applicant has indicated that he does not want to merge them, so something to note.
So would these parcels still be used for like ranch lands or?
Yeah, the applicant has not indicated any change of use, and currently it's just, I believe it's vacant grazing land. I think there was a barn that was under construction when they first applied. I'm not sure how the construction of the barn.
But they're putting it into, this,
Williamson Act?
It's not Williamson Act, it's Conservation Act, is that the same?
California Land Conservation Act, AKA Williamson.
Okay. So it is Williamson.
Mm-hmm.
I thought it was something different. All right.
Anybody from the public on this?
Mr. Chairman, members of the board, my name is Kurt Onoto. I am the applicant. Supervisor Axe, you're correct. The property been used for cattle grazing for at least 100 years, and that's the use that it's currently under that I'm using it for as well. That won't change. I have, as staff pointed out, I've agreed to accept the restrictions to make sure that it can't be switched to ag and turned into a winery or a veterinary clinic or something of that nature. To ensure that it will just continue to be used as cattle grazing land, frankly. The barn is almost done. It's under construction, and the property, it had to be refenced. This is a new parcel of an old family ranch. It was broken apart. So it has about 9,000 feet of new fence that I had to put on the back three sides of it. So I believe it meets all the requirements, and I appreciate your consideration of my application.
Thank you. Anybody else from the public?
Move to close the public hearing.
Hold on. Give me half a second. We got anybody on Zoom?
Not at this time.
Okay, now we can go there.
My motion stands.
Second.
Okay.
Well, it wouldn't be a good spot for a winery because Tonzi Road is not.
Okay, call for the vote on closing the public hearing. All in favor?
Aye.
Opposed? Okay, back to the board for discussion.
Move to adopt the resolutions approving the California Land Conservation Act number 457 and 458. Authorize the board chair to sign resolution and contracts, adopt an ordinance approving the zone change from R1A single-family residential and ag district to the ag exclusive ag district for the subject parcels with the findings.
Okay. Call for the vote. All in favor?
Aye.
Opposed? 5-0. Okay, we're gonna take a half-hour break to have our lunch. And so, I hate that clock. So it's 2:22 right now. We'll be back at 2:52. I know how you eat. order. And we're on to 4C.
Chairman, this is the, AT&T, sorry, never mind.
The discussion of possible action relative to approval of the chairman's signature on a letter expressing concern regarding multiple criminal acts in recent months to the AT&T cable infrastructure.
Well, I brought this, to the chair, and I talked to Sheriff Redmond about this. It appears that he's had, finally had a meeting with a responsible person from AT&T. Mr. Eiley, do you know more about that than I do?
I have not heard the results of that. That was yesterday afternoon, and he was meeting with a number of folks from AT&T, and that's the last I heard.
And I was told by an individual that there was mixed results out of that meeting, some positive and some negative. I think the negative is we don't have a redundant system. Positive is there are some things that AT&T can implement that might help the situation, but ultimately we don't have a redundant system. So there's nothing they can do at the present time about that. Some of the other things that can be implemented may assist in some ways. Frankly, I think we should just hold this item and talk to the sheriff and see where he's at. Since the meeting was just yesterday and I didn't have a chance to talk to him about that issue. So
bring it back to the next board meeting?
Either bring it back or just pull it off altogether, depending on the outcome of his meeting. If he thinks it's still an issue, because the biggest issue was he was not having any response from a responsible person at AT&T. So I would move that we table this item for now.
Okay.
Okay. Okay, I'm fine with that. Yeah, me too. And what's a responsible person? Because I had Bryant Malisi, he reached out to me. He's like the regional director of external affairs.
Well, I guess he had, the first person that contacted him was more like a salesperson for AT&T, and I guess he's finally getting to some executives now that have contacted him and at least had a discussion with him. Okay. So I'd like to, let's just table it, and then if we need to bring it back, we can.
4C is tabled.
Well, I made a motion to table.
Okay.
Second.
I thought we were just doing direction. Okay. We gotta call for the vote. All in favor?
Aye.
Aye. Opposed? Okay, so that is 5-0 tabled. On to 4D.
No 4H.
So I guess they're probably not here anymore.
Thank you.
4H.
Oh, yes,
Yes,
What's
they've
that?
already left.
They've already left, okay.
We'll be in touch to coordinate another date where they can, meet and hopefully be first on the agenda.
I understand.
That might be a good idea.
Everybody wants to be first after today.
4E, Board of Supervisors, discussion of possible action relative to the allocation of ARPA funds set aside for disputed various water and sewer systems within Amador County. I need to recuse myself due to the fact that I am on the board of First Mason Meadow Water Association. So Supervisor Neto, it is yours.
Be right there. I guess I'll just stay right here. Out.
Grab my entertainment.
Water tank replacement.
Okay, what we have here is, the county received some ARPA funds, and we set about $1 million aside to go towards, from the water and sewer districts in the county, to help some of the pressing needs they might have. And so we put out a call for projects and received some projects back. And, we have like a proposed funding for some of these projects. And I probably give the amounts that were requested and maybe the amount that's being looked at, proposed to be given to them. We had the Fiddletown CSD. They're looking to trying to put in a well, like a secondary well, so they have a backup. And they had requested about, $75,000 for a well, $50,000 for PG&E power, $10,000 for plumbing, $5,000 electrical. It's like a total of $140,000, and that was looked to be funded. And then Mace Meadows put in for tank replacement, about $140,000, and that was proposed to be funded. And River Pines had various projects. I know some of them dealt with one of their septic ponds was having some real issues, and they were looking for a little over $101,000, and that was proposed to be funded. JVID had put in for a pump upgrade, $75,000, a water treatment upgrade of $28,000, a billing software upgrade of $20,000, a Ranch Road pipeline of $45,000. Those are proposed to be funded.
So the ones with an X next to them are going to be funded?
Yes.
And this was done by what committee?
It would have been probably the vice chairman working with the CAO.
Okay, so you and Chuck?
It was the chair and the vice chair, yeah, were the committee. But then the chair recused himself, so it was the vice chair.
Yeah.
Okay.
Committee of one.
All right.
So you, and I can keep going down through the list if you like, and that's kind of how.
Just the ones with the X's, and
yeah.
so if we.
No, it's about $730,000, because we're trying to hold some back to maybe help out with equipment for the road crew.
So it's about $250K left over.
Yeah, 260. Yeah.
Okay. Yeah. Okay. All right. I'm good.
And I guess I can continue. So JVID had also requested an office generator and a McCalling meter upgrade and a 36-inch valve installation. That would have been about $120,000 roughly. That part was not proposed to be done, but it's all, it's board discretion. Pine Grove CSD had requested a vacuum truck at $55,000. That was proposed to be granted. Amador Water Agency had proposed Lamel Pump Station at like $566,000, and a Pine Grove 88 project at $235,000, and a lift station $144,000. Those were not funded. They had proposed a Mount Crossman project at $105,000. That is proposed to be funded. And Drytown CSD had proposed a water meter replacement, $22,000, air relief valve replacement at $1,000, an auto flush and meter at say $5,000, and those proposed to be funded for a total of like $28,000. Anyway, yeah, it would basically be about $260,000 to be left over for equipment. I don't know if the board, what the board's desire is on this. Yeah, so X is funded. No X not funded.
I know it's not funded, but would our district?
Supervisor Crew, can you speak in the mic?
That office generator for JVID, couldn't we possibly do that with the air district, depending on what type of generator it is?
I would think so.
We have some money left?
Possibly. I don't know for sure.
It wasn't funded. I was just thinking of another avenue to tell them where they could possibly get the money.
Air district doesn't pay for all of it though either.
True.
I kind of think if we put $1 million aside for the agencies for their projects, that's kind of where it should be used. I understand we need money for roads, but set this aside for that purpose.
We did, but it's kind of board discretion, really. I'm just looking at, we got a real road problem, too.
I know District Two could use Martin Lane paved.
Yeah, no, it's,
Fiddletown, you didn't.
Can we do it for 250,000?
oh, no, Fiddletown, no, that was approved. Probably should have been X's there. That was approved. There's a typo there.
Okay.
I didn't see that.
You have a hand up, Mr. Chair.
Yes. Oh, you want to come forward?
I'll make a comment and then I'll write my name down in the interest of time. Larry McKinney, Amador Water Agency. I would just note with regard to the discussion that's happening now, it's my understanding that the ARPA funds were in categories, most of which were for COVID impacts, and then there was a catch-all fund that was more like stimulus money, which was specified as water, wastewater, and broadband infrastructure. So I'm not sure it can be.
Originally it was. I think then it was opened up further.
I'll defer to your staff on that. That was my understanding. In any event, the solicitation that came out for requests for projects, which was consistent with the board's previous discussion, did say that $1 million from the ARPA fund had been set aside for water and sewer systems. I'm very grateful of the recommendation to fund the Mount Crossman project. That's not the total cost of the project, but because of the criteria that were in the solicitation, we just pulled out the equipment purchases, which are in process now, the materials purchases, because we know that can be done within the time frame very easily, and we're going to do the labor force account. So that's not the total project cost, but we really appreciate the recommendation to fund that project. I would just respectfully request that if there is about a quarter of the funding left over after this recommendation, that that funding be applied to AWA's Lamel Pump Station project. That is a $2.3 million project for a community that only has 55 connections. Receive a $1.7 million grant from a hazard mitigation grant program for that. So the $566,000 that's listed there is our match requirement after a 75% grant. And while that project, which would provide better water supply, including for fire protection for that community, while it does benefit a relatively small community, because our finances are consolidated, any support that we get from this avenue benefits our entire service area in terms of operational cost, and we do serve about 60% of the people in the county. So I would respectfully request that if there's otherwise unrecommended funds out of the $1 million, that they be applied toward that Lamel Pump Station project. And I appreciate the board's consideration. Thank you.
Would you, is the Lamel project more important than the Mount Crossman project?
I don't know that it's more important. They're both upcountry projects. They're both related to reliable water supply. The Mount Crossman project it's very cost effective because we're doing it in-house. We're in the design mode for doing a construction contract for the Lamel Pump Station project. I don't know which one is more important, but from our perspective, because our finances are consolidated, anything that we can avoid spending on one project helps us with everything else. So it benefits everybody.
So if you were to get this, you'd still be short over 300,000.
A little under 300,000. Yeah, it's a little less than if the difference between $1 million and what's recommended, that's 262,000. So if that were all applied, it would be a little less than half of the Lamel Pump Station project. But we are budgeting to meet that match requirement out of operating funds, and of course those funds could be used for other projects if we.
You have 1.7 grant awarded, correct?
Yes.
So if you got that 262, that put you just under the $2 million. So you think the agency could come up with the resources to complete that project?
We're committed to coming up with the resources. We had to give Hazard Mitigation Grant Program, Cal OES, a commitment to provide the match. It's just a question of whether we could then use those funds that are otherwise paid for from this money for other projects that are needed.
We have a long list of needed projects, as you all know.
There was a question earlier, Mr. Eiley, as far as could these funds be used other than for water or sewer infrastructure, and those parameters changed, correct?
They can. We declared the entire grant to be, everything we received to be, revenue loss.
Okay, that was.
So they've all been cleared. We're still trying to keep it towards where the original intent was, but, as far as paperwork goes, it's just like using general fund dollars.
I guess where I'm coming from is I know it's sitting right now up there in the county yard, there's a county sanding truck, and the frame's been on it. And I know this winter they're scrambling real hard at the road department, trying to keep roads cleared, sanded, plowed.
How much does a sanding truck cost?
If I had to guess, I'd say something like that, probably $150,000 minimum.
Buck and a half, yeah.
Probably, I mean, you could probably, if you want to get fancy, you probably spend $200,000. Probably $150,000.
Can we just split off $150,000 for that and give them another $100,000 to the largest water agency?
Well, you got, myself, JVID really got punished with the floods of the end of the year, and they've got another, almost 114,000 requests that I'd like to see us help them. I think we gotta spend $1 million on water and infrastructure. Wish we had more, but there's just, I would prefer that.
Okay.
The unrecommended projects from JVID are 124,000.
124, okay.
And if you took that out of the remainder, it would still leave 138, according to mine.
I'll trust your math.
Every little bit to us helps and would be greatly appreciated.
So what about those two additional allocations?
Well, we just had our budget, where the heck is it, somewhere in here. We're discussing about roads and what to do about them. That's all I'm looking at. I like to help the water systems, the small water system, but also I'd kind of like to help the road department some, because they don't have a whole lot of money. You look at their needs up there too. I mean, we got a lot of old equipment up there in pretty rough shape. Some of it is. That's why I'd like to help the water systems a fair bit, but also kind of help our road department some. I know it's kind of a hard call.
Is there like a compromise that we can do? Something for the road crew, something for the other two waters.
You gotta whittle it down where it's not gonna mean much at all.
Well, how about you get a sander for the road crew? It's at least $125,000.
Are you gonna take that out of JVID?
You could probably do it if you did JVID and, I'm sorry.
How about
4 and 1.
Well, what is JVID's total to?
$292.
So that's what it is right there, 292.
If you do everything, yeah.
And right now, AWA is at 105. So.
I mean, if we had to, I can, we could probably knock off, take Fiddletown, River Pines, maybe like Pine Grove, take some other ones and knock 5,000 off all those.
No, Pine Grove is by far the lowest. They're not asking for a lot.
Next to Dry Town.
What?
Next to Dry Town.
That's true, yeah.
I didn't see Dry Town.
But I mean, I'm just saying that maybe if you took some off some other ones, I'd like to get something for the road department. Just
that.
I would like to give the road department some too, but I think we gotta concentrate on water deliveries as important as roads.
Okay, so how do we disperse the, 260,000 left over? Throw something out there, Supervisor Crew.
Well, you get 124 to JVID. We all thought that might be a good idea.
Yeah, and
I would propose we give the 124 to JVID and the balance to the water agency to go towards the Lamel project.
You know, pretty hard for these little groups to generate much income. I mean, when they only have, as we know, AWA is, still think about that 50% price increase in the city. Haven't got over that yet. So you ought to have wheelbarrows full of money.
Lots of needs, as you all know, based on the discussion on a couple of your items today. Water supply in a large part of the county is still a concern, and we're trying to promote the same idea that Supervisor Axe talked about with regard to roads, as far as being able to promote the idea of infill development instead of sprawl. For that, we need treatment plant capacity. We have a lot of big needs, but any help you can give us on this would be greatly appreciated. If we hadn't consolidated our finances 6 years ago, we'd be looking at the Lamel project and saying, well, we have 55 connections there. We just need $10,000 from each of them to come up for the match. And thankfully, they don't have to deal with that, but we still would appreciate any benefit that can be provided here.
You know, I don't know if we can't, they just need some equipment really bad up there at that, road department. So I mean, I can't support not doing anything for them. I mean, I understand where you're coming from. But that's.
Do you have anything in reserves for equipment, replacement fund for equipment?
We'll have to just do some scratching and see what we can do to put it together, to replace that. That's, there may be some other, ARPA funds available, that we can redirect that have been unused, that we can reclaim.
And those would be the ones I would be
Is that a
prepared
maybe or
to shift over.
Probably.
Okay.
There's
Then
always.
I don't think there's any reason to
If we can do something like that, I could probably live with that.
yeah. I can live with probably.
He's smiling, he's got it over there.
I would move to adopt the list then with the modification of adding 124 to JVID to cover the 3 areas that are uncovered, and then the balance going to the water agency towards the Lamel pump station project.
second.
You have a motion, a second? Or you have to say something to say, Paul?
No.
All in favor?
Aye.
Aye? Motion carries. Motion carries 401.
On behalf of the Water Agency Board of Directors, we'd like to thank you for your support today. Much appreciated.
No, you're welcome.
Reluctant as it was.
I wasn't supporting it, but the board appreciates it, I'm sure.
I appreciate your other concerns as well, so I do appreciate the compromise.
On behalf of the, First Mesa Meadow Water Association.
I know, we didn't fund that one.
No, I heard you. You said it. Just in case everybody cares, there's a speaker in the back room. I didn't have my ear at the door. Okay, we're on to 4F, recommended budget, discussion of possible action relative to the adoption.
Mr. Chairman, we have, comment.
Go ahead, Linnell. Please state your name for the record when ready.
Hi, actually, this is Rocky Raymond from the River Pines Public Utility District. I'd like to thank the board for considering helping us. It's a real help in this really important time for us when our equipment is quite old. It's like some of it's over 50 years old, and we've run out of our replacements. And so it's very timely, and I'd really like to thank you all. Thank you.
And this is
Thank you.
Rocky's wife. This is Rocky's wife, Nell Raymond. And I too want to thank the board. You know, this is so needed. And you really have been a lifesaver for us. So thank you very much. And thank you for hanging in there. This has been an unbelievably long day.
Yeah, we know. Appreciate it.
Yeah. Well, we appreciate you, believe me.
Okay, on to 4F, recommended budget, discussion of possible action relative to the adoption of the 2023-2024 fiscal year recommended budget.
Or anything really to discuss?
No real change.
No changes.
I'll make a motion to approve.
Second.
Well, do we have any public? Nope, no public, okay.
You have anything you want to say on the probably? Do you have any stats in your head?
On the probably of the budget or the ARPA funds?
ARPA funds.
No, I think we're good with, we're gonna be collecting the unused stuff, unused funds, and, we'll bring it back to the board for redirection and, get them spent.
Okay.
As far as the budget goes, just a quick overview, this is the intermediate step of approving the budget for fiscal year 23-24. And, the final budget will come back in September.
Okay, Supervisor Axe made a motion. Do we have a second? I second. Oh, did you? I'm sorry. Call for the vote. All in favor?
Aye.
Any opposed? A 5-0. Resolution creating the Buena Vista Landfill Project Enterprise Fund for collection of fees and payments of the state revolving fund debt service obligation.
Good afternoon. Been a long time coming. Long day.
Oof.
And this is 2 years in the making, this one. We have already created we called it a debt service / CIP fund that we deposited the money into, and the state didn't like that. Their contracts call for an enterprise fund. So I worked with Tacey Oneto-Rune, and I worked with the state revolving fund group, and I got them both to sign off. She worked with our external auditors. And so the only change that's occurring here really is we're redesignating the fund we already created. We're turning it into an enterprise fund, and we're going to, from this point forward, put the money we've been collecting and putting in the Buena Vista CIP / debt service fund, and we're going to put it into what we're going to call the Buena Vista Landfill Project Enterprise Fund.
So this would be no more.
Go ahead.
Amount collected from consumers. It's just what we're already collecting already.
This is what this is a fee that we've already authorized, the board authorized 2 years ago. Essentially to pay for the debt service on the projects we're gonna have to do.
Right.
And then at that point, we had 0.8% financing. We're up to probably over 3% now. So I think our financing, annual financing cost is going from about $100,000 to $150,000. But we're collecting around $270. So there should be plenty of money in there in perpetuity, because as the refuse rates go up, these amounts are a percentage of those rates. So these rates will go up incrementally as well as the rates go up over time. So we should always have enough money to pay that debt service. It'll be a 30-year debt service payment. And I have been assured by the State Revolving Fund that once we get the enterprise fund set up, they are prepared to write our contract and get us moving forward for those projects.
Okay, supervisors, any questions? Public?
Pretty routine.
Zoom? Okay.
Adopt the resolution creating the Buena Vista Landfill Project Enterprise Fund for collection of fees and payment of the state revolving fund, debt service obligations, and concurrently transfer the balance of fund Department 18-100, 1820 to the new enterprise fund.
We have a second?
Second.
Okay. Call for the vote. All in favor?
Aye.
Opposed? Okay, that is done. Thank you
Thank
very
you.
much.
Good job, Jeff. Thank you.
Thought you were gonna chime in a little sooner.
On what?
No,
Oh,
talking to the other guy.
Traffic down there.
okay, 4H. Planning Department, final determination, the board chair's approval of temporary waiver to allow Jackson Valley Quarry to operate outside their authorized hours of operation during an emergency.
Afternoon, again, Chuck Beatty with the Planning Department. Consistent with the use permit conditions for Jackson Valley Quarry, they requested an emergency waiver of their normal hours from 6 to 6, Monday through Friday, to be able to operate this past weekend on June 10th and 11th from 6 to 4 p.m. That request was approved by Chairman Brown and now is in front of the full board for your final approval.
And as you see in your packages, that there was a letter from the, oh shoot, now I forget what agency it is.
It was a reclamation
Agency. So
They needed the product.
they needed the product. Yeah, so there are.
I'll make a motion then to approve the board chair's temporary waiver to allow Jackson Valley Quarry to operate outside of their approved days and hours of operation in an emergency situation.
Second?
Okay. Supervisor Neto, second. Call for the vote. All in favor?
Aye.
Aye.
Opposed?
All right, thank you.
Thank you, sir. Okay, the discussion of possible action relative to adoption of resolution in support of Amador's diverse heritage and future.
I brought this forward, due to maybe, some recent things occurring, and, it's fairly generic, but, I think as a, tourist destination, it's important that we, always, say that we're welcoming and, you know, there's certain behaviors that, you know, we try to discourage.
Oh, you know, yeah, I've been looking at this, and I was wondering if we can maybe carry it over, because we had a lot of stuff in this meeting, and I wanted to look at it a little more fully. One of the problems I have a little bit is it's a fairly generic resolution, but there's some of the stuff being put forth where, I guess you'd say some of the things that are put forth as far as diversity, equity, and inclusion in communities is a concept, but in some ways I find this concept really represents a broader agenda. You discriminate and is ideologically driven, it appears at times.
Well, I can assure you, it's not about that. Basically, it's about, you know, condemning expressions of hatred, racism, and bigotry.
Well, those things happen at times. Not saying they're right, but it's something maybe we've all been guilty of a time or two in our life. I'm sure. I know I have at times. Probably said something to somebody I shouldn't have said here or there. But I'm not sure quite what the point of it is.
Well, we're a tourist destination, and people dressed up like the Klan on Main Street doesn't really look good.
You find people doing stupid stuff all over, I mean.
Yeah, well, doesn't mean we should tolerate it either.
You know,
Look the other way.
I talked to you about this, and this is all driven by the one incident that happened with a group that had either white faces painted, or I'm not even sure if they had clothing covering their face white. But to me, as far as I know, that group could be Antifa. That group could be, I'm saying, I told you when I talked to you, let me finish, please. I don't know who those people are, because everybody that I know in Amador County who protests is proud to show their face. That's why I have a problem with it.
I don't think so, because the guys walking with torches saying the Jews won't replace us, a lot of them got fired from their jobs.
I don't know what they said on the porches, but I just have a hard time knowing the people that normally go out in the street and demonstrate in Amador County on both sides aren't afraid to ever show their faces.
No, we see Bill May pretty regularly. He's got his own little desk over there.
At any rate, it wouldn't matter because we shouldn't tolerate others coming here doing the same.
Frank, I hear what you're saying, but, it's, to me, this, if it's a reaction to what happened on Main Street in Jackson with the masks, it's just the same as a letter to the editor with no signature. It was anonymous, and we're giving them validation by reacting to it. If you would, I tried to get the same point across in a more general point. I got a watered down or defanged version that I could support, but this is something like the one that says that we acknowledge, welcome, and appreciate the contributions of all who reside, work, and visit Amador County. Not too sure about that, is one.
Excuse me?
If you would entertain looking at a watered down one, I brought copies for all to look at, or we can table it.
What's wrong with that? We acknowledge, welcome, and appreciate the contributions of all who reside, work, and invest in, or visit Amador County.
You read the police log?
Well, I think for the most part, the people that reside, work here, and invest in Amador County. So do you want that sentence taken out?
Yeah, in the copy that I had, I leave that out of there. Or if you want to take a look at it, or if you want to table it and bring it back, I know it's been
Maybe bring it back.
But I could give you all a copy to look at.
No, I think that it's a time-sensitive thing. Why don't we just take that sentence out? If that's all right with you?
Yeah, well, look and see what you think of this. I give it to everybody. One thing about it, they weren't.
I think part of the problem too, Frank, is there's been this there's movement afoot where there's certain stuff seems to be out there. You know, somebody wrote something up over here. I taught a person. They wrote something I thought was very interesting. They says, whereas Amador County declares that diversity, equity, inclusion conceptual frameworks have ironically not fulfilled their claim, but have actually stifled intellectual diversity, prevented equal opportunity, and has propagated discrimination against anyone who dissents from these policies. And that's something and it's kind of almost interrelated, I would say, to a certain degree. At least that's how that person viewed it. And I think they're not. I got an extra copy here, Pat. Do I have somebody's?
I thought I made plenty. Oh, okay.
I got a double one.
Yeah, I got a double too.
Well, I have a problem with this. We must therefore support the constitutional rights to free speech and lawful assembly for all citizens. I mean, that just kind of affirms what those guys were doing.
Well, we have, I'm not saying it's right, but we have free speech.
We do, and it clearly says, while we support persons' constitutional rights, we deeply regret and condemn the expressions of hatred, racism, and bigotry. I think it's a no-brainer, a slam dunk. Well, I'll make a motion to approve the resolution as is.
Different public.
You are the public.
Okay, we have a motion from Supervisor Axe. Do we have a second?
I'd make an alternative motion that we bring it back at a future meeting.
I have to agree with Frank on one thing. It is time sensitive, and either we do it today or not do it today.
So we have two motions. Neither of them have seconds.
Well, then I'll make a motion to,
Well, what are you doing, making an alternate motion? Because we still have a motion on the floor.
If you had a motion, it wasn't seconded, then we come up with an alternate motion from Supervisor Neto. Correct.
Yep. I'd make a motion to approve Pat's version.
We'll wait now a second.
I would second that being time sensitive.
Okay, we have a motion by Supervisor Neto for, to go with, Supervisor Cruz alternate, and call for the vote. All in favor?
Aye.
Aye.
Opposed?
Nay.
Okay, it passes 3-2. 4J, review and possible approval of May 23rd Board of Supervisor meeting minutes.
Approval.
Second?
No changes?
No changes.
Wow.
Wow, that's a red letter day.
Call for the vote. All in favor?
Actually, I found some typos, but I.
Oh, okay. All right, Frank, good.
Yeah.
Call for the vote. All in favor?
Aye.
Opposed? This adjourns the Board of Supervisor meeting.
3:30, you were